Good morning, everyone. I welcome you all today on the behalf of ICSI and IBBI. Today's topic for discussion is drafting, pleading, and arguments before NCLT and NCLAT. To deliver the same, we have with us Mr. Rajesh Kumar Gupta sir and Mr. Ashish Makhija sir. Firstly, I would like to introduce Rajesh Kumar Gupta sir. Sir is a seasoned banker with over 28 years of experience in the banking and financial service industries. Before joining IBBI as a Chief General Manager, he was employed with IFCL Limited as a Chief Risk Officer. Prior to pursuing his career in BFSI industry, he gained 5 years of valuable experience being employed with leading automobiles manufacturing organizations. At IBBI, he is heading the advocacy, CPE, international affairs, knowledge management, and partnership division. Now, I would request Sir to please begin with his remarks.
Thank you, Trishna. Am I audible?
Yes, you are.
Shri Ashish Makhija, Insolvency Professional, and all the distinguished participants. Very good morning to all of you. It gives me immense pleasure to address this workshop on drafting, pleadings, and arguments before NCLT and NCLAT, being organized by the ICSI IIP along with Insolvency and Bankruptcy Board of India. We are all aware that IBC, the Insolvency and Bankruptcy Code 2016, has been one of the deepest economic reforms in the recent times. With the support and cooperation of all the stakeholders, including the insolvency professionals, the Insolvency and Bankruptcy Code established the supremacy of markets and the rule of law in the resolution of stress and professionalized the services of the stress resolution, all within a short span of around years of its existence. From providing freedom of exit to rescuing companies in financial distress, to releasing idle resources from inefficient uses, to helping creditors realize their dues, and most importantly, bringing about a behavioral change, a paradigm shift among the debtors and the creditors alike. The list of achievements of the code is a long one. As per the latest Doing Business report, India has made a quantum leap in its ranking in insolvency resolution parameter to 52nd position from 126th rank around 4 years ago. The code provides for reorganization in two ways. First, by rescue of the distressed company through resolution plan, failing which the closure of the company through liquidation. It enables the market to make the choice. The markets usually choose to rescue a company if its business is viable or to close it down, to liquidate it if it is not viable. In terms of parameters like time, cost, and quality of outcomes, the code has delivered a multiple of those obtained under the erstwhile regime. In essence, IBC is the first comprehensive resolution forum addressing needs of resolution, revival, as well as liquidation in case of failure of resolution efforts. An economic law is essentially an empiric one, and it evolves continuously through experimentation. The code is no exception. The code has witnessed 6 legislative interventions since its enactment to strengthen the processes and further its objectives in sync with the emerging market realities. Each of the 6 amendments addressed specific issues which could not have been anticipated earlier. Addressing the issues promptly is testimony to the dynamism of the journey and the commitment of the Government of India to the underlying reform. Pursuant to implementation of the code and with the support of the judiciary, the service providers like you all, the banks, financial institutions, the Reserve Bank of India, and the government, stressed assets have been significantly brought down. However, the stressed asset markets in India is still very large, and which includes the assets represented by the NPAs and also return of assets. We have been continuously striving to make further improvements in the code and address the two of the challenges which we are facing as of now in terms of reduced recoveries and delay in recoveries. To that extent, a very high level colloquium with all the stakeholders participating and piloted by the PMO itself was recently carried out by the Insolvency and Bankruptcy Board of India in the month of November, and large number of recommendations with the help of all the stakeholders, be it the NCLT, the NCLAT, the MCA, the insolvency professionals, the bankers, the other stakeholders which are there. We have been working on these new recommendations which have come up. These are being studied, and once they are examined in details, probably a lot of them, I hope, with the active consultation of the stakeholders would be implemented for the betterment of the code. As regards talking about drafting, pleadings and arguments before the NCLT and the NCLAT, the detailed session would be taken by my learned friend Shri Makhija. However, I can only say that the drafting could be in a manner that it is crisp, however it details all the facts and firmly highlights the prayer at a prominent place. Like I mentioned in the colloquium itself, the adjudicating authorities, the NCLT, the members were specifically talking about they being overburdened with large volumes of data, information, bundles of papers and all. And in the applications which are filed, the prayer which is being sought, that is really mentioned in a very insignificant kind of a manner. And to give an example, like he was mentioning, that in one of the cases, the prayer was mentioned in a very small 2 lines kind of a thing on the page number 186 of the application which was being filed. So the prayer which is being sought, that has to be highlighted, that has to be put across prominently at a prominent place and with all the supporting documents in a manner that the adjudicating authority is not overburdened while the applications are being adjudicated. The enclosures along with the application should be only essential documents without burdening the adjudicating authority, which already we know that they are overburdened with large number of cases and resulting in delays in adjudication. So this would also aid the adjudicating authorities in attending and adjudicating your matters in a speedy manner. Further, the law is already settled except for some few things like the avoidance transactions, with rich jurisprudence which has emerged over the period of last around 6 years. So let us help the adjudicating authorities with case laws and judgments which are already settled so that they can work speedily. In the end, I would like to thank the ICSI IIP for organizing this event in association with the board, and I would urge all the participants to make best use of the opportunity and improve your existing understanding in the subject matter. Thank you.
Thank you so much, sir, for sharing some highlights on the subject. Now, before we begin with the session, I would request for all the participants to please keep their respective mics on mute. In case they have any query, they can raise their hand or post the same in the chat box so that there is no disturbance to any other person. Now, I would like to request Ashish Makhija, sir, to start with the session. Before that, I would also introduce him. Sir is a managing attorney of AMC Law Firm. He is a chartered accountant, a cost accountant, and an advocate. He has over 33 years of rich experience in commercial, corporate, and allied laws. He also holds master degree in law from India and USA. Sir is a professor at Indian Institute of Corporate Affairs. He was a professor at Thomas Jefferson School of Law, San Diego, USA, till 2014. Sir has published several books and research papers to his credit. He is one of the specialist editors of 23rd edition of MC Bandari's Guide to Company Law Procedures, published by LexisNexis in 2016. Sir, on the behalf of ICSI and IBBI, I welcome you to this forum for addressing the participants today.
Thank you, Trishna, and very good morning to all my friends, and also very good morning to Mr. Rajesh Gupta. I think I was hearing him very carefully, and in his brief address, well, he mentioned that we should also file very crisp and very brief kind of pleadings before the judges so that the adjudicating authority is able to adjudicate. And I think he has also taken a cue, and he was also very brief and very crisp, and he has covered the entire gamut in just 10 minutes or 15 minutes. I think we must appreciate that. Well, what he said is absolutely right. Because as a lawyer who is appearing before NCLT, and prior to that, of course, I was a standing counsel for the official liquidator in Delhi High Court, dealing with all insolvency matters, and also appearing before the company law board, the erstwhile company law board. Well, I have seen over a period of time that as lawyers, I think what lawyers are doing, they are actually definitely overburdening the litigation. In the sense that I'm not blaming the lawyers for that, but at the end of the day, when we make, you see today what is happening, an application for approval of a resolution plan, can you believe it runs into 2000 pages nowadays? Now, does it need to run into 2000 pages? It does not. In one of the cases, what we saw, the RP had held, say, 20 COC meetings, and he attached minutes of all 20 COC meetings in the resolution plan, showing that, look, I did this in first meeting, second meeting, third meeting, and going up to the 20th meeting. You need not attach. At the end of the day, if you are going for the approval of the resolution plan, the minutes of those committee meetings where resolution plan was considered, say maybe 19th or 18th or 20th, because it would be considered only 1 or 2 or 3 meetings. So probably you can attach those minutes, or maybe the relevant portion of those minutes also. And then, of course, the voting pattern and other things. But at the end of the day, this is very crucial thing. And naturally, friends, drafting and pleading and arguments, all these three are an art. So we need to learn that art, and that is extremely important. So friends, before I start, I think this was just an overview. I'll share my presentation also. But before I do that, may I request everyone, I think Trishla can also request everyone, she requested that to please keep your audios, mics off, but I will request you to keep your videos on. So at least, because I believe that is also the norm when you are attending. So I'll request everyone to please open their videos so that I can see the smiling faces. I don't want to speak to the blank screens. I think it will be more interactive for each one of us. So it will be wonderful, requesting everyone, all participants, to open their videos so that at least we are able to interact. And you can keep your audios off for the moment, but if you need to discuss, you need to share your experience, you need to ask any question, you need to make any comment, yes, at that time, probably you can raise your hand and you can tell me, so that give me a signal so that I will stop, and then we will have a discussion on that particular aspect. So friends, let's begin in the right earnest. I'm glad some of you have already opened videos. I'll request others also, if they're in a position to open the videos, it will be a good interaction, like we are having a physical interaction. So I think it will be an interesting thing to do so. Now, friends, one of the important aspects that adjudicating authorities, dealing with the adjudicating authorities by the RPs, particularly the insolvency professionals, it cannot be missed. You cannot ignore it. You cannot avoid it. So what exactly needs to be done? Because one of the biggest questions that is asked to me is that when we move an application before the adjudicating authority, or when we are going there for pleadings and arguments, do we need to hire a lawyer? Or can an RP in his or her own capacity can present the case before the adjudicating authority? Well, friends, the answer is absolutely yes. As an RP, you are competent and you are entitled to present your case. And in any case, whether you are arguing your case on your own or whether you have a law firm for the argument, or any lawyer, my request to each one of the RPs is to please be present at the time of the hearing. Now, it may so happen at many times, like you are handling, say, 7-8 cases, and say 3 cases are listed at the same time. Well, you can't be present in all the hearings. I know that. In a virtual hearing, of course, you can have 3 laptops where the matters may come at a different time. But if it's a physical hearing, it is very difficult to be present in the 3 courts at the same time. But it will do good you must try, make every effort to attend all the hearings. The reason is very simple, friends. You are the master of your own game. You know better facts than anyone else. Even if you hire a law firm or a lawyer, now they or he or she may not know those much facts which you know. So whatever facts you tell them, probably they're preparing the application, or whatever they can discern from the records. But at the end of the day, if any question is asked, well, what we call it as outside the syllabus, then definitely a lawyer will not be able to answer. You will still be able to answer. Like, how many COC members were present in the meeting? I don't think a lawyer will be able to answer that question. Who voted in favor? Probably he knows that 78% people voted in favor, but who voted exactly and what was the percentage of, say, ICICI Bank or SBI? Probably you have better facts than anyone else. So it is always better to assist that person. So be present in that portion. I mean, in most of the hearings, because this is one thing which we have seen. The benches have been asking this question, where is the RP? Even if you're not saying anything, they just want to see the face and they feel confident. So therefore, it is extremely important, friends, that if you make yourself available for the hearings which are happening, it will definitely expedite the case. It will not be a cause for adjournment. Because at the end of the day, what the lawyer will say, okay, my lords, you may kindly give me time. I'll seek instructions on this particular question. Now, for every question, if he starts seeking instructions and then therefore he's asking for adjournment, then the matter gets delayed. So this is also, we have seen that this has also become a trend. So it is better to be present in most of the hearings. Now, friends, let me share my presentation with you. Okay, I don't know why I'm not able to share it. I don't know why it sometimes gives difficulty. Trishla, what I'll do is I'll just leave the session and come back again because sometimes it
sir.
corrects the error. So let me just leave the session and I'll come back again on this.
Sure, sir.
Yeah, just give me a moment. Okay, friends, I'm back. Trishla, can you just make me the co-host so that at least I'm able to share it?
Pardon, sir?
Yeah, no, I'm able to share it. Okay, thank you. So yeah, I think now, friends, you are able to see my presentation.
Yes, sir. Yes, sir. It's visible.
So, friends, this is, you see, we are going to talk about pleadings. Now, when we say pleadings, you see, when we talk about pleadings, now what do you mean by pleadings? Because we are talking about today the drafting, pleadings, and arguments. Now, pleadings is like a formal submission to the court. Now, whatever application you are making, whatever facts you are giving to the court, and supposing an application has been filed against you, supposing you have rejected a claim and the claimant actually goes against you and says, look, RP has rejected it wrongly. So therefore the submissions are made or the pleadings are made by the, you see, person whose claim has been rejected. And then you also kind of file a reply to that. So both the things, like the application and its reply. And the third thing is, typically when a person who moves an application, he or she is also given a chance to file a rejoinder, isn't it? So we have got three things: application, reply, and its rejoinder. All these three things combined are known as pleadings. So pleading is a general word, you see, which gives you the entire gamut of the whole case. So these are kind of allegations, counter allegations, and denials. So those kind of statements which are made, but they are known as formal submissions. If we look for the language, you can say the definition of the word pleading is formal submission to the court stating on cause of action. So what is the cause of action? Now that's more important. If you are moving an application, obviously you have a cause of action. Now, supposing you are moving the adjudicating authority for extension of time in the CIRP period, you have a cause of action. Now, that cause of action emanates from what? You have to explain those circumstances. That look, the CIRP started on so and so date, it ended on so and so date. Now, there was, you see, we require certain more time because these things are in the pipeline. And we have gone to the COC. COC has already approved it. So therefore, we are moving this application. So therefore, you have to state all the facts in seriatim. You have to state all the facts in a logical manner. And as Mr. Rajesh Gupta also mentioned, I also endorse a statement, material facts should be disclosed. I mean, I don't want to disclose in between, like supposing for extension of time. Now, in extension of time, If you say, oh, I made a public announcement and so did, so many claims were received, I verified those claims, so many claims were admitted. What is the need for this? These facts are unnecessary for the extension of time application. So whatever comes to your mind first, please write down whatever you're writing in your pleadings or whatever you see the applications is there. But then you must edit that. Cross out whatever is not relevant. But first, don't stop your mind. Let everything be written on a piece of paper. Once it is written, then you have to start editing those things. So written allegations, statements of the parties in a legal and a proper manner, stating the cause of action. Now, cause of action is extremely important. Supporting somebody's claim has been rejected. Now, what is the cause of action? Rejection of the claim is the cause of action. Now, that person must list out what were the facts behind this. When did he file the claim? In which form he filed the claim? What was the amount of the claim? And then what were the correspondence exchange between the RP and that person and what he clarified? And then what were the reasons for the rejection given by the RP? Now, once these facts are stated in a chronological manner, I think the bench will be in a position to identify those. And then what are your grounds of you see, supposing RP said, I'm not admitting your claim on say 1, 2, 3, 4 grounds. That you paid cash to the company, there is no record of cash. So therefore, I'm rejecting the claim. Or I'm rejecting the claim on the ground of limitation. Your claim is time barred. Or you have filed a belated claim, whatever could be the reasons. Now, then the person who is moving an application, he has to give grounds of defense that, look, I'm challenging the action of the RP on these grounds. So grounds of application are extremely important. So first portion will cover, you see, the facts of the case. Second will be what are your grounds? And lastly, as Mr. Rajesh Gupta also mentioned, that portion will contain the prayers. And I'll come to those prayers also, how to draft those prayers in a meanwhile. I'm just parking that. But look at this. In pleadings, as I mentioned, a person can file an application, a petition, or an appeal, right? So in IBC, we called it as an application. But generally speaking, when you file an application under section 7 or 9 or 10, right, for starting the CRP process, they are generally nomenclatured as petitions. If you look at it is numbered as CPIB, company petition, within bracket insolvency and bankruptcy, and then the number is given, and then the year is also mentioned, 3496 of 2022. That number is given by the registry. That number is not given by you. So you will file that application writing it blank. And then you will write off 2022 or 2023 or whatever year is there. But you will leave that number blank. When all objections and there are no discrepancies in the application, then registry will number it according to their own sequences. So that numbering is given later on. But the applications that are 7, 9, and 10, they are treated as main case. So therefore, they are generally called as CPIB, right? So company petition, insolvency, and bankruptcy. But every other application, whether under extension of time, whether for non-cooperation of the suspended directors, or whether for any other damn thing under IBC, or maybe under for avoidance transaction also, they are known as applications. And they are generally called as interlocutory applications, IAs. They are to be numbered as IAs, interlocutory application number dash of 2022 in CPIP IB number so and so, so and so. So application is always filed in the main case. Because otherwise, where the registry will put it in their DMS? If you are filing it electronically or even if physically, how will they come to know that it is to be tagged with which file? So main case is also mentioned that. So petition, application, or appeal, its reply, replication, or counter. Well, any word can be used. Typically in before adjudicating authority, we are using the word reply. But in some benches, they may use the word counter, particularly in South. You can say in Madras bench or Bangalore bench, sometimes they'll say, oh, have you filed counter? So counter here means reply only. Somewhere, some people may call it as replication also. So don't be confused with nomenclature. This remains the same thing. Then Generally speaking, a chance for rejoinder is also file rejoinder is also given. So rejoinder is filed by the person who has filed the application. And then, well, I've mentioned here sir rejoinder and sir rejoinder. Well, in ordinarily, these are not allowed to be filed. But in exceptional cases, even a sir rejoinder may be allowed to be filed when, supposing in rejoinder, well, you are supposed to state all the facts. You are supposed to attach all the proper documents in the petition, application, or whatever it is. And in the reply, then you will mention and counter those allegations and also attach maybe some more documents. That is why the person who is filing the application is given a chance to file a rejoinder so that he meets with those documents, supposing some new documents have been filed in reply. But now, if in rejoinder, he takes some more grounds or he or she files some more new documents. Now, the person who has filed a reply can always object that, look, these documents were not filed earlier. I was not given an opportunity to meet these documents. So therefore, I must be allowed an opportunity to give a sir rejoinder. Well, generally speaking, it is not allowed. This practice is not, you can say, as a matter of rule. But yes, in exceptional circumstances, because in one of our cases, the opposite party filed 50 more documents, not 50 documents to support their case, which they did not file at the initial stages. We objected. We said, how can either we requested the bench either not to take these documents on record so that they can't argue. And if you are taking it on record, then please give me a time to file sir rejoinder on this, which was allowed to us. So in some exceptional cases, it can be allowed. So don't, and in one of our cases, even sir rejoinder was allowed, but that is too extreme. So anyhow, let's not get into that, but these are the things. So everything, whatever is filed by any of the parties, that is combined known as pleadings. When the court uses the word whether pleadings are complete. Now you must understand that the court is asking whether all applications, reply, rejoinder, everything on the record, whether the matter is ready for arguments, whether we can begin arguments today, because arguments can only be heard when the pleadings are complete. So if the pleadings are not complete, nothing can happen. So it is our duty as an IP or RP to make sure that the pleadings, whatever time frame is given to us to file a reply, the pleadings are complete in time. Because if we don't complete, supposing the court says, supposing today your application is listed and a notice has been given to the opposite side, say you are filing a avoidance application against, say, 10 parties. So it says notice issued. Generally, the order will be notice issued, reply to be filed within 15 days, rejoinder, if any, to be filed within 7 days. Now, 15 days time has been given to the opposite side to file reply, and 7 days has been given to the opposite, the UU to file a rejoinder. Now, what happens generally, the opposite side does not file within 15 days, they will file, and the next date is, say, after 1 month. So because by that time, all pleadings should be complete. But generally, we have seen the trend that before the next date of hearing, you will get a copy of the reply just 1 day before the next date of hearing. So obviously, this hearing has to be adjourned because you will take time to file a rejoinder. So that is the practice which we should avoid. As an RP, if we are given 7 days time or 15 days time to file a reply or a rejoinder, we must stick to it. That's what you see. It will expedite the whole process. It is very easy to blame NCLTs that they are not doing anything. But if you look at most of the cases, you attend any bench hearing on any day, out of 60 matters, in 40 or 30 matters, pleadings are not complete. Because either the copy has been filed 1 day before or 2 days before, the other party is not ready for argument. So if we can do this in time, I think this will also save a lot of time for the adjudicating authorities. Now, friends, these are some definitions which are given in NCLT rules. Now, this is another of my tip, friends. Since you are dealing with IBC, and in IBC, adjudicating authority is NCLT, and NCLTs have been appointed not under IBC, but they have been appointed under Companies Act. Now, under Companies Act, NCLT rules have been framed. NCLT rules have not been framed under IBC because NCLT have been constituted under Section 408 of the Companies Act. So therefore, all the rules have also been made in the Companies Act, under Companies Act. So NCLT Rules 2016 also defines the word pleadings. And this is a very detailed definition. I'm not reading it for you, but just please look at this definition. It says it means and includes application. I'm sorry, including interlocutory application, petition, appeal, revision, rejoinder, reply, statement, counterclaim, additional statements, whatever it is, supplementing the original application and reply. So pleadings is a broad term which includes all the documentation which is supporting that particular case or the reply or rejoinder. This is a very wide definition. And then even petition is also defined. Petition can be a petition or an application. So even an application can also be treated as a petition. So don't get confused with the word application or petition, or an appeal or a complaint in pursuance of which any proceeding is commenced before the tribunal. So when the proceeding is commenced, so please understand, when the proceeding is started, by filing an interlocutory application, you're not starting a fresh proceeding. Fresh proceeding under IBC started under 7, 9, or 10. Now that is definitely termed as petition. Typically, it is termed as petition. But if you are moving an application within that CP number, then you are not starting, you are not commencing any further proceeding. You are commencing a proceeding within a proceeding. So therefore, that is also to be taken care of. Similarly, interlocutory application. Interlocutory application means an application in any application or original petition. Look at this. Why we call it as an IA? Because it is an interlocutory application within the main petition only. We are not starting a fresh proceeding in an application. Proceedings are already going on. Main proceedings are already going on. So where the proceedings are instituted for the first time, that particular application is termed as petition, but interlocutory application is an application within the original petition, which is already going on, right? But there is one more aspect. Supposing an order has been given and then the order has not been complied with. Now, what is the option which is left with you? Well, you can approach, because you can approach the NCLTs for execution of the order. Please execute your orders. Or you can also file a contempt. Now, execution application or a contempt application is considered as a separate petition. Contempt petition, it is generally termed as contempt petition. Execution petition or execution application, it is still considered as an execution, right? Because it also says interlocutory application is not being a proceeding for execution of the order. So this definition is absolutely clear in Rule 215. So my request to my friends would be that please go through NCLT rules. They are extremely important. And of course, NCLAT rules are also there. Then it also defines application. So I don't want to read this thing for you. And then it also gives a meaning of the word applicant. So a person who is moving an application is known as the applicant. And if we go to CPC, of course, friends, CPC, Civil Procedure Code 1908, does not apply to IBC proceedings. We are very clear on that. But there are certain definitions, because CPC is of 1908 and it has stood the test of time. And it gives us a whole lot of definitions and gives us a very fantastic idea of pleadings and arguments. So here it says pleading shall mean plaint or written statement. This is their word which is used. Because in CPC, what happens in civil proceeding, let's not get confused. Whenever an application is filed under civil procedures, as a civil proceeding, like you file a recovery suit, it is not known as application or petition, it is known as plaint. Right? Because, and the person who is filing is known as plaintiff. The word plaint has typically come from the word complaint, right? So it is a plaint. And then the person opposite party, the person who is made as a defendant in that case, is asked to file the reply, and that reply in CPC is known as written statement. We call it as WS, written statement, right? In IBC, we don't call it as written statement, but we call it as reply, right? Or replication or counter. But in civil proceedings, it is known as plaint, filed by plaintiff, and a written statement, which is a reply filed by defendant. We call them as defendant. We don't call them as respondent. In IBC proceedings before NCLT, we call it as petitioner or applicant, and the opposite party is called as respondent because they have to respond, right? They give a response. So this is a slight difference. Don't get confused. And in criminal proceeding, it is little different, right? In criminal proceeding, the person against whom it is filed is known as accused. They're not known as rejoined defendant or respondent, but they are known as accused. Okay. Now, this is a very good guidance. Order 6 of CPC, because I believe my friends are aware that CPC is divided into different orders also. And Order 6, Rule 6, Rule 2 talks about, Order 6 talks about pleadings. And Order 6, Rule 2 says pleading to state material facts and not evidence. Look at this. Such a fantastic guidance we can get from CPC. So state only material facts, my dear friends. Don't state immaterial facts. Every pleading shall, when necessary, be divided into paragraphs. I have seen, friends, some pleadings starting from top of the page, and that paragraph continues even to the next page without any full stop, without any commas, no breaks. Do you think you will be in a position to read in a continuous manner? It's impossible. No one, and everyone loses the meaning. Everyone loses the energy to read that. But if you make short paragraphs, say of 7, 8, or 10 sentences maximum, I think everyone would like to read that. Maybe at reading at glance. But you can draw your attention of somebody if you divide into paragraphs. So divide into short paragraphs, and they should be numbered consecutively, 1, 2, 3, 4, or whatever way you are wanting. And then each allegation being contained in a separate paragraph. Don't mix up things. And similar to this, there is a judgment of the Supreme Court in IBC, and I'll quote that judgment. Well, the question that arose before the Supreme Court was, in JP's case, that whether a combined application under section 43, 45, 49, and 50 can be filed, or separate applications should be filed. Of course, this was not a question before that, but it came up incidentally. And the Supreme Court commented. They said, look, section 43 is independent of section 45. The parameters to prove the case under 43 are different from what are required for in 45. 43, I believe my friends are aware, it talks about preferential transactions. 45 talks about undervalued transaction. So the parameters to demonstrate that this is a preferential transaction and the parameters to prove that it is an undervalued transaction are different. So if you simply state in one paragraph that, look, I am claiming 20 crores as preferential transaction and 10 crores as undervalued transaction from such and such party, the judge will get confused. So allegations relating to preferential transaction should be contained in separate paragraphs. That is one part of it. But here the Supreme Court also commented, not in a very, you can say uncertain terms, but yes, commented as an observation that it is better that if the allegations are segregated relating to preferential, relating to undervalued, relating to fraudulent transaction and extortionate. Meaning thereby, in an indirect manner, we get a meaning, and most of the benches are now insisting, based on the JP Kensington judgment, they say, look, you should file separate applications for section 43, separate for 45, separate for 49, and separate for 50. So please make it a point that you file separate applications for that. Now what happened, you see, with this? When one of the bench commented, then what happens? Look at the you see sequence, how people understand this, how people interpret this. Now in preferential transaction, there were 40 parties. Amount was to be claimed from 40 parties. So this can happen. Like if your forensic auditor points out. Now that gentleman, that lawyer, what he did, he filed 40 applications. So preferential transaction, but he filed 40 applications for each of the parties. No, that is not required. So can you believe 90 applications were listed on the same day before the bench? And the bench got irritated. He said, what is this nonsense going on? We did not tell you to file separate applications for each party. So you can make in a single application 10 respondents also. So please do not go into literal meaning of what the judges have said. So please make sure that you only file 4 applications, right? If there are the cases. So separate application for preferential, maybe you can make 10 or 15 or 20 parties. That is fine. So this is, please do take care of these things. Then in fact, in pleadings, you will be surprised to know, and this is mentioned in NCLT rules also, that the dates, sums, and the numbers must be written in words also. Sums definitely, sums definitely, like we write rupees 1 lakh, then in bracket we write rupees 1 lakh only. We typically write that. Generally we write that, but nobody writes the date in words. Do you write it? I know that practice in 1991, since 1991, when we were filing applications before Company Law Board, we were writing all dates in words also. 17th day of December 2000, say 1992 or whatever. But nowadays nobody writes that. Anyhow, it is a requirement under NCLT rules also. It is a requirement under CPC also. But yes, at least take care to write the numbers and the sums at least in words also, because even if you write something wrong in, there is a difference between the number and the words, then words will be taken as a precedent. So whatever you write in words will be taken as the correct one. So therefore, please do make it a point to do that. And look at this, Rule 7, Order 6, Rule 7 CPC, what does it say? No pleading shall raise any new ground of claim or contain any allegation of fact inconsistent with the previous pleading. So once you move an application, please state all your facts together. Don't make a new ground or a new pleading later on. Well, the law is, this is very logical. If you make allegations against me, supposing I am a respondent, I must know what you are trying to say. Now, if you keep on adding to the allegations, then I must answer those. And this will delay the whole process of the pleading. So therefore, it is also very important. But supposing, if you have missed out a very important portion, supposing you moved an application, but you are not aware of the fact, because as an IP, I discover many, you can say, information at a later stage. So I discovered some information which was very important. Then I will not, add on in my rejoinder, but I will move an application to the adjudicating authority for amendment of the pleadings. I will tell them that, look, this document was not known to me earlier. This has come to my notice just now. And for us, it is very important for the adjudication of the case or adjudication of the matter. So please allow me to amend the pleadings. So this is an exception. So if you forget anything, please ask for amendment of the pleadings or amendment of the application. Do not add anything without the permission of the court. This you must take care of it. Otherwise, the opposite party will object to it and you will be in trouble. And then every pleading shall be signed by the party or by any person duly authorized by him. So if you are the RP, you are supposed to sign it. And it must be accompanied by an affidavit. That's very important. So affidavit has to be filed with every application. Without affidavit, application has no meaning. It can be, generally, what I have seen in some cases, only lawyer signs. And then the name of parties does not sign. No, that is not the correct procedure. The party who is making those amendments must sign it. So it will be your name. Supposing if you are the RP, you must sign it. And then of course, through so-and-so law firm, that can be written. That's all right. But only lawyer signing it and not the party, that is an incorrect procedure. So this is not a correct procedure. And of course, affidavit, I think I've already mentioned that affidavit in support of the pleadings to be verified. And affidavit has to be on a stamp paper, non-judicial stamp paper, but that stamp paper value, some people ask me, well, friends, I will not be able to answer what will be the value of the affidavit. It depends on the state because it is a state subject. So go to the stamp paper rules of each state. You will find it on the internet, download it, you will be able to find out. So if 100 rupees is the affidavit amount in Mumbai, it may be 200 rupees in Chennai. So we don't know. So therefore, please be careful while purchasing the stamp paper for any affidavit. Okay. So, and the court generally are very liberal in allowing the amendment of the pleadings, right? Because you must prove to the court and say that, look, the real question in controversy is to be decided. And only these documents can help you to decide. So courts are generally liberal. If you look at the jurisprudence on Order 6, Rule 17, which is amendment of pleadings, well, definitely the courts have been very liberal in the past also. But you have to make out a good case that, yes, these documents are necessary and proper for the determination of the real question in the controversy. Otherwise, they may not allow it. So this is extremely important, okay? Now, this is also very important, friends. Supposing an application has been filed against you as an RP, and you have to, supposing there are 20 paragraphs. Can you just make one sentence and say, all the averments in the application are denied, are incorrect and denied? That is not sufficient, friends. Every paragraph, every sentence, if you are not agreeing, you must deny that. Your opening sentence can always say the averments made in paragraph 1 are incorrect, wrong, and denied. That is all right. Then you will say it is specifically denied. It is denied that RP rejected the claim on so-and-so basis. It is denied so-and-so, so-and-so, so-and-so. And then you can state your own case. But denial is extremely important, friends, and denial has to be specific for each sentence, because opposite party can tomorrow take a stand. Oh, I made this averment and RP never denied it. And if you do not deny, Rule 5 of the Order 7 CPC says it is considered as admitted. Look at the consequences. If your denial is general and not specific to every sentence, then it may be treated as an admission on your part. So you will be in trouble. So therefore, friends, please make it a point that every important aspect which is mentioned in paragraph is denied if you wish to do that. Now, let us come back to NCLT rules. Friends, when you are moving any application under section 7, 9, or 10, now, what are the rules which are applicable? Under IBC, we all know that application to adjudicating authority rules have been framed, right? Now, those rules have to be followed. That particular thing, you see, rules have to be followed. Because if you look at section 7, what does section 7 subsection 3 says? An application shall be filed by the financial creditor in such manner, in such form, and along with such fees as may be prescribed. Now, what do you mean by such manner? What do you mean by such form? What do you mean by such fees? Where will you find it? You will find it in rules. Because in IBC, and I've been saying it consistently, and most of you are aware, in IBC, friends, if you want to note down, 2 important phrases are used. And I'll just give you one formula how to decipher that. The first phrase which is used in the entire IBC is as may be prescribed. As may be prescribed is equal to rules, is equal to central government or Ministry of Corporate Affairs. Who makes these rules? Naturally, the government has to make it. Central government makes it. The second phrase which is used in the entire IBC is as may be specified. Now, as may be specified is equal to regulations is equal to board or IBBI. Now, who makes the regulations? Obviously, the regulator makes it. Now, you may be wondering, what is the difference between rules and regulations? I think that question must be in somebody's mind. Well, friends, number one, they are of the same category. Number one, what is that category? This is known as delegated legislation. Laws and the statutes and the act is framed by Parliament or the state legislature. But then some powers are delegated to the central government. That look, legislature does not want to get into that, but you frame that. So rules are framed by the central government. This is known as delegated legislation. And similarly, there are regulations which are to be framed. So both form in the category of delegated legislation. Now, what is the difference between rules and regulations? Well, typically speaking, there are not much of a difference, but rules are generally relating to the initial starting of the proceedings. But like once in IBC, the proceedings start, then it is a matter of procedure. So therefore, procedural part is given to the regulator to regulate it. So therefore, the regulations will come into force. Like I can give you a very good example. If you look at from section 7, from section 4 to section 12, right? You will find the word as may be prescribed. But from section 12A onwards, section 12, 13, 14, 15, and going up to the section 31 or 32, you will find the word as may be prescribed, because then the CIRP starts and CIRP is regulated, and therefore you will find regulations more. So this is the whole this thing, the law has been drafted. Now let us look at the AAA rules, application to adjudicating authority rules. Rule number 10 states that the rules which are contained in part 3 of NCLT rules shall apply. So while filing a section 7, 9 or 10 application, you have to comply with rule number 1 to 9 of AAA rules. But then rule number 10 says that rules 20 to 26 of part 3 apply. But what are those rules? I've given that broad this thing. So part 3 of NCLT rules deals with institution of proceedings. But it contains from rule 20 to 33, but IBC has adopted rule 20 to 26. Okay, they have not adopted all the 14 rules, but they say 20 to 26 will apply. And in fact, if you look at very carefully, even 25 does not apply. It says 20, 21, 22, 23, 24, and 26. So even 25 is also missing. Anyway, well, I'll come to that. Now, what are those rules? So typically, it talks about, you see, what should be the language. If the language is other than English, then it's a translated copy of the document must be attached. Petition must be in double space. It should be a standard petition paper which should be used. What should be the margins? Left margin should be minimum 5 centimeter. Right margin 2.5 centimeter. And similarly, top margin must be 4 centimeter. This is the requirement, friends. Left margin is always higher than the right margin. And then top margin is also to be there. Every page should be given a number, paginated. Index must be attached on the top of it. And then it must be bound in a paper book format. Where if you're filing physically, it should be bound in a paper book format. Either it can be stitched or maybe properly stapled or whatever, or tagged or whatever you can do, but do it very carefully so that it comes in a paper book format. So this is very, very important, friends. So these are the requirements which are mentioned in, and you will get it from NCLT rules. And the heading on the top of it, how do you get that heading? This is also mentioned in NCLT rules. It says before the National Company Law Tribunal, New Delhi bench, principal bench, Chennai bench, Bangalore bench, or whatever bench it is. Or even if bench number is given, so you must write that. New Delhi bench 1, New Delhi bench 2. Similarly, Chennai bench 1, Chennai bench 2. Divide into paragraphs, numbered consecutively. Party details you must give. Like supposing you have made 10 parties as respondents. So you must give their name. If you know about their father's name, parentage, age, description, address. So those things must be given. And parties must be numbered 1, 2, 3, 4. Don't club in one item number 1 only. So write down 1, 2, 3, 4, and so on. So because then they will be called as respondent number 1, respondent number 2, respondent number 3. And then, of course, under which section you are mentioning, you are filing this application, that is also required to be mentioned, right? Under the cause title. Application under section 7 of the insolvency. So that should be the heading also. So this section is also required to be mentioned. Then similarly, address for service to be filed. Well, why this rule is there, let me explain. In fact, when these rules were framed, and I must share this, and I'm very happy to inform you that when these rules were being framed by NCLT rules and NCLAT rules, the Ministry of Corporate Affairs, constituted a committee to do that. And I was also part of that committee. So I have also contributed towards, these NCLT rules and NCLAT rules. So why this address for service to be filed? Actually, if you read very carefully NCLT rules, supposing you are making an application under Companies Act, because actually they were framed under Companies Act. Say you are filing an application for operation and mismanagement under 241, 242, whatever sections are there. So we said that, look, you have to file 3 sets of the petition, right? 2 for the bench members and 1 will be for the registry, for the court master. And then supposing you have made 5 parties as respondents, then once a notice is issued, because at the first stage when the application is dealt, a notice is always issued to the respondents to file their reply. Then at that time, it was required that as many respondents as there are, then as many copies you were supposed to file to the registry, along with the address on which they is to be served, and the registry was supposed to send a notice. So you were supposed to give them a complete envelope, right, where their addresses will be written, and similarly you will also pay the stamp and whatever, the postage stamps and all that. And then the registry was supposed to send the notices. But frankly speaking, friends, this practice has not been started in NCLTs. What the practice which continues is that when the court says notice issued means now the person who has filed the application, he is responsible to send the copies to all the respondents. So typically speaking, it is the person who is filing the application, now the responsibility is given to him. So address for service is not required generally, but yes, this was a requirement which was there. So alterations to be initialed, 3 copies to be filed. So this is a requirement. 3 copies of every petition or application are required to be filed. And documents which you are attaching must be certified as true copies, because you are attaching photocopies, you're not attaching originals. So each copy or each annexure or each document which you're attaching, the person who is signing it must certify as true copy. Either they should do it or the lawyer should do it. But generally speaking, lawyers don't do it. So it is the parties who are to sign the as certified as true copies. Index is required. Name and address signature of the person who is verifying is required. And then any defects which are pointed out must be removed within 7 days. And then, of course, affidavit must be attached. So these are the processes which are there. Now, these are the rules which have been framed under IBC. I think most of us are aware. The first are application to adjudicating authority for filing applications under Part 2. Then under Part 3, 2 rules have been notified: application to adjudicating authority for insolvency resolution process for personal guarantors to corporate debtors rules. So if you are moving an application for insolvency resolution process under 94 and 95, well, you'll have to follow these rules. If you are filing an application for bankruptcy of the personal guarantors to corporate debtors, there are separate rules. So please look at these rules and then be careful to file to follow these rules. So manner, form number, and the fees will be mentioned in the rules. So you'll have to find out from there. Okay. Just like you see in AAA rules, there are 10 rules, 7 forms, 1 schedule. Schedule only talks about the fees which is to be paid. And similarly, these are the forms. So I'm not mentioning it, but only I'm just pointing out one thing. Rule number 4 and rule number 5, not 5, 6 and 7. 4, 6 and 7, friends. There is a change effective from 24th of September 2020. During COVID period, amendment was brought in the rules. And now the rule says that if you are filing an application under 7, 9 or 10, you must serve a copy of the application to IBBI also. Right? Earlier, it was only that it should be served at the registered office of the corporate debtor, but they added the word "and" to the IBBI before filing with the adjudicating authority. So IBBI wants a copy of application of 7, 9 or 10. And that is to be filed electronically, not physically. Okay. So this is the requirement which has been brought in Rule 4, Rule 6 and Rule 7. Okay. I just wanted to point this out. Okay, friends, now let us come down. Anything up to this stage, friends, before I move forward? Any questions, any comments? Okay. I mean, you can unmute yourself if you want to ask any questions, or if you want to write in the chat box, maybe I can deal with there. Okay, there is one question. Could you please repeat the point on party signing the application along with the RP, please? Okay. Mr. Ramesh, I just mentioned that, look, if you are making the application as an RP, it is your duty to sign that application. The last page of that application, you must sign. Because generally, sometimes we have seen that lawyers are only signing it and not the RPs or the persons who are making the application. So it is important that you must do that. That's extremely important. So this is what I mentioned. Okay. Okay. Purnimaji is asking, what if the main petition is withdrawn and there are still some pending matters? Okay. Purnimaji, if the main petition is withdrawn and then main petition is allowed to be withdrawn, right? Then even if it is not specifically mentioned in the order, then all interlocutory applications are also treated to be withdrawn. Because interlocutory applications are not independent applications. Those applications are in the main application.
Can I come in here, sir? I have a question. Actually, this is a practical experience which has happened in one of this.
Okay.
This interlocutory application actually came into being also because of the main petition was withdrawn. See, the main petition was withdrawn under this section 12, and this the RP is pending to be paid. Now, so the interlocutory application obviously it was not part of the main petition before it was withdrawn. It has to come later on, but they were not the main petition was withdrawn. Okay, so we can always revive this main petition, something like that.
Okay, see, there are two things. Well, typically, see, if you are asking for a legal position, the legal position is that if the main petition is withdrawn, then nothing survives. All the interlocutory applications are deemed to be withdrawn, right? That is one, it is there. But you are raising a very interesting question, and this we have seen in practical circumstances. Supposing the main petition is withdrawn, and that is allowed to be withdrawn also, right? But the fees of the IRP is not given, and that is an important issue. IRP, where he will go? If his application is also deemed to be withdrawn, then he will be in trouble, isn't it?
Exactly.
So therefore, sometimes the benches are saying that, look, this application, we are keeping it on record. We'll decide on some other date, but all other applications along with the main petition are allowed to be withdrawn. But if there is no clarity, then if that is also deemed to be withdrawn, then obviously the RP will have to move an application for restoration of that IA. So that is
we can restore the main petition.
Yeah, absolutely, because that has to be decided.
On exigency.
Not exigency, it is a normal thing, because at the end of the day, you have not decided the fees of the IRP. So IRP is also to be paid, isn't it? So that's about that. Okay.
Thank you, sir.
Yeah, thank you. And one of the participants by the name iPad. Okay. Shall we sign on all pages of the application? Well, the answer is yes, you must, because you must initial all the pages, because otherwise, you see, somebody may change the page tomorrow. So then what will be the this thing? So it is to ensure that, yes, all pages are correct. You must sign on initial on all pages and sign full on the last page of the application or the petition. Can the application be digitally signed using DSC? Well, friends, nowadays, you see, DSCs are an acceptable thing. You can definitely sign it. But once you are submitting it in a physical format also, then DSC signatures will not matter. So then you will have to sign it physically also. If you are filing it electronically, if you want to use your digital signatures, nobody is denying that. So that can be done, right? Okay. Okay, I believe there are no more questions.
Sir, one question, can I ask?
Yeah, please go ahead, sir.
Sir, if in a CRP, if resolution plan is filed before the adjudicating authority and still some IAs are pending, and what will be the outcome, or how the NCLT will decide before they have to clear all the IAs and then only approve the resolution plan, or how it is?
Yes, the answer is yes, because you see, at the end of the day, what are those applications? Those applications are some claimants might have filed the application. Now, if their applications are not decided before the resolution plan is approved, and supposing the resolution plan is approved, then what is the fate of their application? So therefore, yes, those applications must be decided before they decide the resolution plan application. This must be brought down to the notice of this. And generally speaking, the benches are also trying to decide all the applications which are pending before they are taking the final application for the resolution plan. That is to be done.
Including the buffet applications.
Now that's an interesting thing. Okay, let me deal with that. I wanted to deal with it a little later, but let me deal with that. As far as avoidance transaction applications are concerned, which we call it as PUF transaction or PUFA, whatever you may call it. Well, there is a judgment of Venus Recruiters of Delhi High Court, right? And that has not been challenged before the Supreme Court. So therefore, it has attained finality. It is binding on all NCLT benches. Now, what that judgment says? That judgment in its term says that an application which is filed by the RP or the insolvency professional, once the resolution plan is approved, he cannot pursue or continue with that application, because this person has become functus. He is considered as an erstwhile RP and cannot be considered as an RP. So therefore, avoidance application cannot be pursued by the RPs after the plan has been approved. He becomes a functus person, right? That is what. And in the same breath, they have also written one more sentence, that even NCLTs cannot decide because they become functus officio. See, they say that, look, what was the important point? That the plan is the last thing. So if the plan has been approved, what is the power of the NCLT now? So they say the case is closed. So they become functus officio. And once they become functus officio, how can they adjudicate on an avoidance application? So even this sentence is also written. But in the same breath, in the same judgment, another thing has been written. That if in the resolution plan, it is mentioned that the avoidance application will be continued to be pursued by the COC members or by the RA or by the IP, right? Obviously, IP can also be authorized. So if some kind of this statement is written, then these applications can continue after the approval of the resolution plan. But if your resolution plan is silent, who is going to pursue it? Then they say nobody can pursue it, and even NCLT cannot adjudicate it. So this is what is the meaning of Venus Recruiter judgment of Delhi High Court. Having said that, whether this is the right or wrong judgment, we are nobody to comment, because if it's a judgment of Delhi High Court, we are all bound by it. But at the end of the day, so what is the takeaway? The takeaway is, my dear friends, that whenever a resolution plan comes to you, please make sure that it contains a clause that avoidance applications, if not decided before the approval of the resolution plan, can be pursued by whom. There must be clarity. If there is no clarity, assuming, because in the past, supposing you have already done that, the plans are pending, then you must insist before the adjudicating authority that, my lords, please decide this application first, because if you don't decide it today, tomorrow you will also not be in a position to adjudicate because of Venus Recruiters. So I hope I'm clear on this, sir. So first thing is, make sure that the plan talks about it. If the plan is silent, because your plan is already approved by COC, you have already moved, you can't do that, you can't change it now. So then you must insist that before deciding the resolution plan, you must show them Venus Recruiter judgment and say, please decide this, sir, first before you approve the resolution plan or reject the plan. Okay. So this is extremely important, friends. Now, one more thing in Venus Recruiter, which is, again, there is a small dichotomy. See, I mean, we can't comment because this is by honorable judges, we can't say anything. But they say that assuming the company slides from CIRP to liquidation, supposing the plan is rejected, they say then the liquidator can pursue those applications. So if the plan is approved, nobody can pursue it unless it is specifically mentioned in the plan But if the company slides to liquidation, then the liquidator can do that. So this is one of the important things which you must need to know about it. Okay. Okay. Let's go forward. Now, friends, we were talking about drafting and pleadings also. Now, drafting, if you ask me, it is an art. No doubt about it. It's not a science because it comes from the mind, right? It can definitely be learned. And it is a skill which must be acquired, can be acquired and must be acquired. Now, how it can be acquired, I'm going to give you certain tips on that. Number one, friends, whenever you are, using a very simple language is the key. Don't use complicated language. I'll show you one example, friends, that what kind of language is used, which nobody understands. Use a very, very simple and an understandable language. Like supposing the directors are not cooperating. Why do I have to complicate things? I have to write very simply that at the date, on the date of the commencement of the CIRP, that is insolvency commencement date, following persons were the directors of the company as per MCA records, copy of the MCA record attached. This is important evidence. You must attach. The judge may ask you. Then as an RP, I have written communications to respondent number 1, 2, 3, or whatever dates are there. You must write down on the following dates communications are for to cooperate and to give them documents, including accounts and other things. However, out of 17 items which I asked for, only 5 have been provided and 12 have not been provided, or nothing has been provided, whatever the facts of the case. I'm just taking an example. So be very clear about it. Attach those communications which you have sent. Attach the proof of those communications also. And you must make sure that you are sending it by speed post. Sending it by courier is fine, friends. You can do it as an additional, but please always make it a point to send it by either registered post or speed post. And then you have the tracking facility of the speed post and the registered post. Track it, attach the tracking report, whether it is delivered or not. That delivery report will, clinch the deal for you. I'm telling you. Courier receipts.
Can we send on email also?
Yes, sir. Absolutely. Emails are absolutely acceptable. But what happens, sir? Somebody may deny this is not my email. Okay, एक email तो आपको मिल जाएगा MCA के record, so you will definitely get it from there. So do that. And then if you know the DIN number, then probably you also can access the email address of that particular director also. So do that, sir. That's a good observation which has been made by you. Please send it by email in addition to sending it by registered post or speed post or courier. Okay. So please do that. That's very, very important. So once you do that, then you write down all those steps in a very, very simple and easy language. Don't use any complications. So make it very clear to the judge. I asked for these documents because the judge is going to ask you, okay, Mr. RP, tell me what documents are pending. Now, if you have not written in your application, how will you come to know of it? So prepare a chart, a table that, look, I asked for 10 items, only 4 were provided. So 6 are pending. Then the judge will grill that person. So this is extremely important that you must give complete details and use very, very simple language. Clarity must be there. And no ambiguity. Sometimes you see people are writing in a very, very ambiguous manner. You don't understand what you want to write. And you need not be verbose. Verbose means don't use too many synonyms, right? If you use too many synonyms, then it becomes a problem. So synonyms is not required to be used. Now, one word is enough. You don't have to write awesome, wonderful. You can use only one word. That's all, right? And the test is, once you have read it, also make sure to see whether that word is necessary or not unnecessary in a sentence. So if you find that it is unnecessary, then you, like some people do write, the director assured me to revert back. Why do you have to write revert back? Revert is a good word. So back is not required to be used along with revert. So use that, see that whether these kind of sentences are words are really, really required or not. Because what happens is, at the end of the day, what you are writing will cause confusion, may cause, different interpretations. And then petition can be dismissed, prayers can be refused. because of the vague or the ambiguous nature of the prayers or vague or ambiguous nature of the facts which you are writing. Now, I have seen many application, friends, and can you believe in first prayer in most of the application, because everyone is copy pasting it. Nobody is applying its mind. I mean, I'm very sorry to say, but this is actually happening. Everyone who wants to draft 19.2 application, the first thing he asks for, what can I get a template or a sample? I asked my people in my office also, I said, be original, draft on your own. Why do you need a sample? So don't look for any samples, friends. Please draft it. I think if you will be able to do that. Now, what is the first prayer? Generally. And the prayer column, it says that you see, in view of the aforesaid facts and circumstances, the applicant hereby prays, most humbly prays, that this honorable tribunal may be pleased to A, allow this application. Why do you have to write this word, allow this application? Allow the application means what? And grant prayers as may be deemed appropriate. Now you want the judge to apply his mind on the prayers. So your prayers have to be absolutely clear and unambiguous, friends. Don't write these kind of general sentences. You should simply, like if it is a 43 application, you should say respondent number 1 should be direct respondent number 1 to pay rupees 20 crores to the corporate debtor, or bring this property so and so back to, revert this property back to the company. So this is extremely important, friends, that your prayers must be absolutely clear. You don't want to leave anything on the judges. I've seen avoidance applications being prepared in this manner. And don't write the word allow this application. Naturally, if you are seeking prayers, you are asking for allowing of the application only. Why do you have to write this word? So don't write that, and don't write appropriate reliefs or something. That you can write in the end, right? Pass any or further or other orders as this adjudicating authority may deem fit and proper under the facts and circumstances. This is just a collateral right. Supposing you have not asked for any prayer, so you can cover in that, but your main prayers must be there. And friends, please remember, whenever you go to a religious place, right? You go with the folded hands, you go and ask for some prayers, isn't it? Your prayers are always in your mind or in your heart, isn't it? You go to the highest lords. This is also a temple of justice. So whenever you're going to before my lords, you are asking for prayers. So you have to be very specific. If you don't ask for the specific prayers, how the my lords will going to grant that prayer? So be very specific insofar as the prayers are concerned, friends. So this is extremely important. And look at the importance of the short sentences which we were talking. Look at this sentence. Supposing somebody is writing, the body is agreeing to this budget as the financial mechanism to support the education priorities of the school as identified in the school development plan, and will adhere the best value principles in spending its school funding allocation. Now, friends, if you have to write a shorter sentence for this, what you will write? Well, I'll show you in the next slide. Board approves the budget. Why do you have to write a long sentence when you are simply saying that the board has approved the budget, whatever was required? So be very brief rather than writing unnecessarily, you see, in a roundabout fashion. Please write short sentences. This is extremely important, friends. So legal writing skills, number 1, friends, will start from your legal knowledge. You will not be able to draft any application unless you know that provision. So if you are making an application under section 12.3 for extension of time of CIRP, you must read 12.3. Without reading section 12, how will you be able to draft it? Then second, of course, the knowledge of facts. That is an input. So facts must be there. So you have to start writing down those facts. And output is the prayers. So these are the 3 things which you require. Once you have these things, so 1, legal knowledge, facts of the case, and why you are going to the court. What are your prayers? If everything is clear in your mind or written in short on your paper, then, my dear friends, you have to start creating a story in your mind. Now start visualizing. What should who are going to be the parties against whom I'm seeking the prayers? So you will define the parties. That is the first step. If you don't define the parties, your application will go haywire. So first decide what are your prayers. So on the basis of the prayers, who are the parties against whom you are seeking the prayers? Because prayers are always linked with the parties. So decide the names of the parties. Then you should start writing the facts of the case. Then you should write the grounds of the grounds for the application. And then at the end, you will write prayers. And your prayers must be extremely specific. So create a story in your mind, friends. If you create a story in your mind, the thread will not be lost. Mark my words. So writing is not that easy. It's something extremely important. Do not copy paste. This is my suggestion. Well, even if you copy paste, but please apply your mind. That's very important. Okay. Change the facts of the case. That's very, very important. So identify the facts, research the law. That is what Mr. Rajesh Gupta also mentioned, that today the jurisprudence in most of the IBC matters is already there, isn't it? So the members may not be aware of a judgment passed by a Supreme Court or what is the interpretation. So as you can say the officers of the court, it is our responsibility to bring it to their notice that, look, my lord, Supreme Court has decided this. So therefore, please interpret it this. So if Supreme Court has already done it, they are bound by it under Article 141 of the Constitution. Similarly, if something has been decided by the high courts, definitely they are bound. If anything has been decided by NCLAT, all NCLT benches are bound by those judgments. So please bring it to their notice and research those on that particular area. So use the law and facts to create a document, and obviously the prayers, which I have already emphasized. I think I don't need to emphasize it more. Now, supposing you are a lawyer or you are helping the client. Now you need to discuss with supposing lawyers have to discuss with the RPs, isn't it? So you have a video conference or a physical meeting, understand the problem, understand the facts, and then you should start making the case. Because if you don't understand the problem or the case, I don't think you will be able to draft that. So then facts have to be segregated into relevant facts and not so relevant facts. That means material facts and irrelevant facts. So write only the relevant facts and do not write the irrelevant facts. So build a story and start writing bullet points first. Like, what are your grounds? Just write in a bullet point that my first ground is that this application is barred by limitation. Okay, I'll expand it later. Then second, even assuming that it is not barred by limitation, then it is not, this is not the correct submissions made by the person concerned. So all those points you have to jot down in a bullet format. So this is extremely important. If you do it like this, you'll be able to argue also in a proper manner. So legal writing skills are extremely important, friends. Okay. Okay. So let's go to, sequential factual presentation. Now that sequential is extremely important. If you don't present it in a sequential manner, well, nobody is going to understand. And in one paragraph contain one allegation only. Don't mix up 2-3 things, because I've seen even my office people are also drafting. Sometimes they're drafting in very confusing manner. So therefore, we will have to change that style and then state the grounds. And in grounds, friends, please understand the legal grounds must be taken at first, right? Like supposing there is a suppression of facts of the case. So suppression of facts is a legal ground that you can say that please dismiss this application. Then if there is any violation of the principles of natural justice, that should be your second ground. And third will be the factual grounds, depending upon the importance of that particular ground. So this is the style in which you are going to write a reply, or when you are writing the grounds for that. Well, names of the respondents have to be decided in any case, and then prayers. Again, I'm emphasizing the prayers. The prayers must be there. And prayer column should be separately. You should write prayers. Don't mix it in a paragraph. Prayers. Write in a bold, and then you start. In the light of the above facts and circumstances, this honorable tribunal may be most graciously pleased to A, B, C, D. What are your prayers. Okay. So this is the way you should draft it. To help the courts, yes, one is known as memorandum of parties. Memo of parties must be written in one page, right? Petitioner versus respondent number 1, 2, 3, 4. So all their full addresses to be written, because on every this cause title, you don't have to write the full address on every page. Just write the full address of the respondent on the memo of parties. That's all. After that, when you are starting the petition, you can simply write petitioner, whatever, say RP versus, you can say first name and others. You can just simply write and others. But if you have described that in memo of parties, the page before, then it is good. If you have not, then you have to write names. Prepare synopsis of your application, because your application may run into 18 pages, 20 pages, or 30 pages. Now, what do you want to tell the judge? So just in 1 page or 2 page, summarize that and create a synopsis of that application. So they will just read, say, 1 paragraph or 2 paragraphs. Well, they will understand the problem. Of course, they may not know the greater details, but at least that will be in their mind. Oh, what this application is for. Because if you have been appearing before NCLTs, what is the first question they ask? A, who has filed it? B, okay, what are your prayers? So they straight away go to prayer page. Then they say, okay, why are you asking for this prayer? Please explain now. So then the argument starts on that. So list of dates is also important sometimes. Like directors not cooperating. List of dates are very important. How many communications did you send? On what date? So list of date means you will give the date and you will describe what happened on that date very briefly. So prepare that table and chart and give the list of dates separately to the judges. Attach with the application. And of course, index is very important. That is the first paper. Affidavit, in any case, we have discussed that it has to accompany. And then after the affidavit, then you will attach the documents in a sequential manner, right? Annexure number 1, annexure 2, annexure 3, or whatever is document. And try to, supposing you have written 3 emails, right? Say in October, November, and December. Now, one thing is you can club them and attach all the 3 emails as annexure number 1. Or a better way is October email is annexure 1, November email as annexure 2, and December email as annexure 3. Tell me which one is better. The second style is much better, because if the judge has to, supposing you say, my lords, I have attached at annexure 1. Now in annexure 1, there are 3 documents. Now you may be reading something different, judge may be reading something different. But supposing in one annexure you attach only 1 document, well, that is always a better thing to do. So make as many annexures. Whatever annexures are necessary, do that. So if you attach 17 annexure, 20 annexure, doesn't matter. Ultimately, the volume is not much, in the sense, in one annexure, you are attaching 17 documents or you're creating 17 annexures. Well, it doesn't make much of a difference, but it is ease of reading, you see, which is very important before the courts. So please do that. That is also extremely important. Okay, Praveen Garji is saying, please repeat the importance of memo of parties. Okay, friends, memo of parties is what? Memo of parties is the short form of writing memorandum of parties. Now, definitely when you are moving an application, you are the petitioner, supposing you are moving it. And then there will be, say, 10 respondents. Say you are moving an avoidance application. So what you will do is you will write on the top, before the NCLT so-and-so, in the matter of so-and-so, then you will write in the matter of petitioner, whatever the name is there, the name of the corporate debtor or your name, versus, then you are writing number 1, so-and-so XYZ, respondent number 1. Then B, respondent number 2, C, respondent number 3, along with the address. This is known as memo of party. This is a separate sheet, right? Now, after this memorandum of parties, now you are starting the main petition. So in main petition, again, you have to give the entire, format of that, cause title, before the company law, before the NCLT, so-and-so, so-and-so. And in the matter of here, you need not write all the parties. You can simply say, in the matter of, say, XYZ corporate debtor versus A and others respondents. So you need not write, because you have given the details in the description in the memo of parties. This is what.
Nothing summary, no summary is required in this memo.
No, in memo of parties is only memo of parties, sir. Okay.
Only name of the party.
Only names of the parties and all. And in synopsis, you will have to have, you see, if you look at on your screen, you'll find I've
Okay.
written the word synopsis. Synopsis is nothing but a summary of the case.
Thank you, sir.
This will again be a separate case. Okay. This will be a separate document. What I'll do is we'll take a break in between, then I'll show you one prepared document, a petition which is prepared. I'll show you very quickly on your screen also, right?
Yes,
Once
sir.
we
Yes,
take
sir.
a break in between. So I'll give you that. And if you want a template also, we can provide that template also. That's not a problem. Okay.
Thank you, sir. Thank you.
Okay. Sentences must be kept short also. Can you believe in one of our cases, my office people drafted one sentence was at least a half a page. And when I started reading from the top to the bottom, I lost the meaning. Even I could not understand. I had to read it 5 times. So the point, and every sentence was joined with and. Then I told them that, look, this is the first sentence which is complete. Put a period after this, put a full stop, start another sentence, then another sentence. So make short sentences, friends. I think you will be in a position to, convey your message. But if you write long sentences, I think the meaning gets lost. I'll show you one example also, right? The text must be simple and concise. Like, I'm just giving you 1 or 2 examples. If I have to write the word in conformity with, why do you have to write 3 words? I can simply write conform. Make amendments to. Why I have to write 3 words? I can simply write amend. So all I'm saying is try to, do it in this manner. This will be there, and adopt the active style rather than in a passive style. Actually, what is happening is, we have been taught the English in the same manner that we generally write in a passive manner. That's what we have seen. I mean, there is nothing wrong in that, but writing an active, a sentence in an active style is always better. Like passive sentence would be, this contract shall be governed by the laws of India. Nothing wrong in this sentence. And this is our style. In India, everyone writes like this. But can't we write Indian law shall govern the contract? Tell me which one is better. Now supposing somebody receives money, right, or letter, how he writes, I acknowledge having received your letter. Why do you have to write acknowledge? Simple, you say, I received your letter. So all I'm saying is sometimes we use unnecessary words also. Try to cut down on that. So that is very, very important. Look at this. Now, this is one of the sentences which has been written in an actual application, right? Under section 9. Look at this. What the person has written. Due to the fact that the corporate debtor has not paid the money owed to our client against bills raised to the tune of 1.10 crores, it became imperative to send a demand notice under section 8 of the IBC, and upon its failure to make the payment within 10 days, the applicant hereby has preferred this application under section 9 of the IBC to initiate insolvency proceedings against the corporate debtor. Now a sentence of, a whole paragraph containing almost 8 to 10 sentences without any full stop. Now, how will you write it? If you have to reshape it, look at this. Since the corporate debtor has failed to pay dues of the applicant after service of demand notice, the applicant was constrained to file this application to initiate insolvency proceedings against the corporate debtor. Tell me which one is better. So the idea is, instead of writing, 10, sentences, we could have written only 5 sentences. Look at this. These are 10 sentences in a small format. These are 5 sentences in a bigger font. So if I write in a small font, it will be only in 4 sentences. So this is the way you will have to redraft, friends. That's what I'm saying. You will have to do that. So what is the rule? Write liberally, edit ruthlessly. You have to be ruthless while you are editing it. Omit unnecessary and extra words, and if it is required, please rewrite it. Writing is an art, my dear friends. Drafting is an art. Okay. So, I mean, whatever comes to your mind, please write at the first stage, because those ideas are not going to come back again. But once you have written it, please edit it. And the best way is also there that supposing you have a group of IPs or you have a group of your friends, you give this application to somebody and say, please edit it for me, peer review. Similarly, you can also edit for somebody else. I think this is the support which we can give it to each other. So this is the way to present the things with that. So proofreading is also important. Whether the sentences, spellings are right, whether the sentence is making sense or not. Construction of sentences is very important. Spell check is extremely important. If you write wrong spellings, the meaning may change. Punctuations are also very important. Where to put comma, full stop, semicolon, whatever. Of course, grammar, I can't say much about it. This has to be correct, no doubt about it. Otherwise, the meaning gets lost, right? So this is very, very important. Now, I'll show you one sample. Let me try to find out one sample of ornamental writing, which is not required to be done. Okay, I'll just show you one sample if I'm able to see it. Yeah, I think I'm able to find out. Let me see if I can share that quickly. Okay. So friends, I think you can share now. You can see the PDF file. Can somebody confirm that they're able to see this?
Yes, we can.
Yes, sir.
Okay. Well, friends, what is this? Let me explain. This was exactly, you see, a judgment written by the former Chief Justice of India. When I read that judgment, and that judgment, my dear friends, if you look at that judgment, that is a 268-page judgment, and it contains 200 paragraphs. So you can imagine that sometimes one paragraph is more than 1 page also. And such a tough language has been used. And I wrote this blog, right? Of course, I did not publish it, right? मुझे लगा कहीं contempt ना हो जाए तो मैंने publish नहीं किया. I did not publish it, but let us read it. I mean, let's read it. So I have written, India is a land of contrasts. Half of the Indians probably do not know English language. Out of the remaining half, a minuscule percentage has grasp of strong English vocabulary, right? Then I've given some statistics also. Then these words which are written, and look at this. This is the judgment name, and the judgment name is Subramaniam Swamy versus Union of India, right? And this is a judgment which was rendered on 13th May 2016. So this is the judgment. If you want to find out, you can also find out that judgment out. Now, this is a 268-page, 200-para judgment, and it begins with such an eloquence and continues in the same manner till the end. Now, let us look at the few paragraphs which I want to just read it along with you, right? Or maybe any of our friends would like to read it. Anyone who volunteers to read it loudly so that at least everyone understands?
So
Okay.
can I volunteer? So Nitin,
I
can volunteer. So is it that the same judgment defamation? I mean, is it by Justice Deepak Misra?
Yes. Go ahead, please read it.
Just read it, sir. Okay. So this batch of writ petitions preferred under Article 32 of the Constitution of India exposits cavil in its quintessential conceptuality and percipient discord between venerated and exalted right of freedom of speech and expression of an individual, exploring manifold and multi-layered, limitless, unbounded and unfettered spectrums and the controls, restrictions, and constrictions under the assumed power of reasonableness ingrained in the statutory provisions relating to criminal law to revive and uphold one's reputation. The assertion by the Union of India and the complainants is that the Reasonable restrictions are based on the paradigms and parameters of the Constitution that are structured and pedestaled on the doctrine of non-absoluteness of any fundamental right, cultural and social ethos, need and feel of the time for every right, engulfs and incorporates duty to respect others' right and ensure mutual compatibility and conviviality of the individuals based on collective harmony and conceptual grace of eventual social order, and the assever- uh, asseveration on the part of the petitioners is that the freedom of thought and expression cannot be scuttled or abridged on the threat of criminal prosecution and made uh, paraplegic on the mercurial stance of individual reputation and of societal harmony. For the said aspects are to be treated as things of the past, a, a symbol of colonial era where the ruler ruled over the subjects and vanquished concepts of resistance, and in any case, the individual grievances pertaining to reputation can be agitated in civil courts, and thus there is a remedy, and viewed from a prismatic perspective, there is no justification to keep the provisions of defamation criminal law alive, as it creates a concavity and unreasonable restriction in individual freedom, and further progressively mars voice of criticism and dissent, which are necessitas for the growth of genuine advancement and a mature democracy.
So, well, friends, here Nitin actually, but I'm going to read it. Look at the second sentence. Second sentence starts from here and goes up to the even to the next page. I mean, it is consisting of almost around 20 sentences, 20 lines. One sentence containing of 20 lines, what meaning can you make? And look at the words which have been used. Please tell me, friends, whether the judgments are written for bagging the English literacy awards or they are written for the common man.
Good.
For everyone to understand, actually, at the end of the day, it is the lower courts which must understand this judgment to apply. It is for the common citizens of the country to understand these judgments. Look at the language and then look at the, you see, synonyms which have been used. Look at this. I'll just read the first sentence once again. This batch of writ petitions preferred under Article 32 of the Constitution expose its cavil in its quintessential conceptuality and percipient discord between venerated and exalted rights of freedom of speech and expression of individual. Now look at this. Exploring manifold, multi-layered, limitless, unbounded, and unfettered. Now the judge has used 5 synonyms. What was the need for using 5 synonyms? Multifold is the same meaning, multi-layered is the same meaning, limitless is the same meaning. And then it says controls, restrictions, and constrictions. Same meaning. Under the assumed power of reasonableness ingrained in the statutory provisions relating to so and so. And similarly, if the second sentence structured and pedestaled, same meaning. Every right engulfs and incorporates, same meaning. So why do you have to use synonyms? And this is exactly, you see, if you look at any legal drafting today, friends, you will find tens of sentences. Now, you can use it. There's no point, there's no harm in doing that. But at the end of the day, it loses its meaning. And these are the words which have been used, which are extremely difficult for anyone to understand, isn't it? And friends, mark my word, this is only the first paragraph which we have read. There are 200 paras in this judgment, and most of the paras are like this. I have highlighted some of the paragraphs here. Now, what all I'm trying to say is that look at the language which has been used out here, right? So what I also wrote, and look at these paragraphs which I have pointed out. Now, I also wrote the eloquence with which the judgment has been written requires magistracy to polish their English understanding skills sooner than later. The judgment is definitely a lesson to all law schools to ensure that besides the rule of interpretation of laws, they should also concentrate on teaching how to decipher judgment through English lectures to law students. The judgment does what it intends to do as far as law is concerned. The question that arises is whether use of such elegant words are required in a judgment that is meant to be read and understood by the ordinary persons with reasonable prudence. No judgment is written for bagging English literacy awards. The judgment is definitely sequential and deals with all legal aspects in a chronological manner, but the language used is too ornamental for ordinary mortals to understand. Direct expressions rather than elaborate phrases are what are desired in the judgments. My lords, we the ordinary mortals be spared from turgidity and verbosity. मैंने भी थोड़ी सी इंग्लिश मार दी यहाँ पे turgidity and verbosity. So it is this judgment is definitely verbose. Verbose means you are speaking too many words in the same breath. So it is definitely a very important lesson for us not to do this, friends. This is extremely important that we should start learning that, look, this is not the way which we are going to draft the whole of the things. Okay. So friends, let's do one thing. I think we'll take a break here. What is the time there, sir? Nitin, can you just tell me what is the time there?
It is 12,
11:55.
11:55,
Almost
sir.
12.
11:55. Okay. So can we take a 10 minutes break if
Sure.
my
Yes, yes.
agree?
Sure.
Yeah.
Yes,
All right.
sure.
Okay. So friends, we'll
Go
meet
ahead.
after 10 minutes and then we will continue.
Okay, thank you so much.
Okay. Thank you. Okay, friends, shall we start now?
Sure, sir.
Yeah, okay. So, friends, welcome back. Those who have not joined, may I request you to please join and open your videos. I mean, once I'm requesting you. Okay, so now what we have done is we have talked about the drafting and what is the meaning of the pleadings and all. So any questions till this time, so that at least before I move forward, now I'm going to actually deal with giving you certain tips on how to appear before the adjudicating authorities and what are the precautions you must take. I think that's also very important. So how, in any case, to build your arguments in a particular case. So that is also extremely important. But before I do that, any questions, any comments from your experience, if you want to just share it with other participants, I think that will be wonderful. Okay. So if there are no more comments, I think let's move forward. So friends, now I am actually going to a very interesting part, which is the kind of art of pleadings, basically, in the sense that how to present your case before the NCLTs. Now, that becomes extremely important for a very simple reason, that everything depends upon how you present your case. Well, naturally, when you are arguing, when you are presenting your case, I mean, in the form of a pleadings or something, that's fine. But you need to understand that every bench is kind of a, short on time, isn't it? Let us look at one of the scenarios. You are sitting in the seat of a judge. 60 matters are listed before you. Will you be now? And in every matter, there are more than 5, 7, 10 applications listed. This generally happens. You look at the cause list. So if you are a judge, will you be in a position to decide all these 60 cases in a single day? The answer is no. It is practically impossible. Now, because if any argument starts on a single application, minimum 10 minutes or 15 minutes, one party will take, other 15, 20 minutes. That is why I'm saying only minimum. Sometimes it goes beyond 30 minutes, 45 minutes, or even 1 hour also. On another day, an application was filed against one of the corporate debtor, and I was defending the corporate debtor. The bench asked me, Mr. Makhija, how much time you're going to take? I said, minimum 45 minutes. He said, no, we don't have time, don't have that much of time. You look at the cause list and the docket of this thing. So we can give you only 10 minutes. I said, Manoj, I can't complete my arguments in 10 minutes. Let's be very upfront. Because here it's a case when you are sending a company to CIRP, I need to defend. I need to show so many documents that there is a fraud which has been played by this party. So at the end of the day, they said, okay, we'll give you 30 minutes. Well, I don't have any options, so I started. But you believe it or not, I took 30 minutes on 2 days. So I argued for 1 hour. So all I'm saying is that, look, everyone is going to argue in that manner, 15 minutes, 30 minutes. I mean, every application is going to take 30 minutes. So if there are 60 multiplied by 5 applications in each case, 300 applications are there. Do they have that much of time? They don't. So all I'm saying is, even though you're going to take 15, 30 minutes, but be very precise with your arguments, because they will stop you in between if you are making a very long argument. So therefore, narrate your facts in just 5 minutes and then go to the documents which you want to show them, and also quote the legal cases which are there. So this is the art which you need to develop. That is extremely important. But before we do that, friends, now let us look at one of the important things. Now, this is what I say. When we were in schools and colleges, friends, we were carrying a pencil box. Now, what does that pencil box used to contain? Now our kids, maybe, of course, they might also be grown up now, but what do they carry in their pencil box? Well, pencil, pen, eraser, scale, or whatever stuff which is required, isn't it? But now we are grown-ups. I mean, we are professionals. Now we don't require to carry a pencil box anywhere. But friends, Hemaji says color pencils also. Okay. No doubt about it. Color pencils, erasers, compass, even photos also, isn't it? Right? Okay. So now we need not carry that pencil box. But friends, mark my words. When you are appearing before the adjudicating authorities, please carry a pencil box. And this pencil box, my dear friends, will not carry the stuff which you were carrying it earlier, but it will carry 2 important things. One is rules of interpretation, and second is principles of natural justice. You will require them because everything depends upon interpretation. So if somebody wants to interpret, you need to immediately counter that and do that interpretation by way of the rules of interpretation. So here, what I'm just stopping here now before I move forward. In your personal library, my dear friends, you need to have at least 2 books on interpretation. And I'm going to quote those books today. Please note it down if you wish to. And I'll request one of our friends to write it in the chat box also for the benefit of everyone. The first book which I'm recommending you on interpretation is Maxwell on Interpretation. Maxwell, Maxwell, Maxwell on Interpretation. So I'll request one of our friends to write in the chat box also. And maybe if somebody is a computer savvy, they can go on Amazon or Flipkart and see where it is available. Go on Google and see wherever it is available. This is a book which is written, this is a UK book. This is a British book written by a British author. It is not by an Indian author, but this is an excellent book. It's a not very thick book. It's roughly around 250 pages, but it is an excellent book on interpretation. The second book which you need to have in your library is an Indian book, and that is Principles of Statutory Interpretation by Justice G.P. Singh. Okay. Statutory Interpretation by Justice G.P. Singh. It is a thick book. It runs into 3,000 pages. So please have these 2 books in your library, and not only have it, please read them also, because that is also very important. So these are 2 important good books. One is an Indian book, and of course, the other is the.
Please repeat the name of the author for the English version, Indian version, sorry.
Indian version is Justice G.P. Singh. Okay. And Maxwell, of course, is Maxwell, right? Okay. So I have these 2 books, and I think this is extremely important. Now I'll tell you, I'll narrate you see a very interesting thing, because there is another, act for interpretation, and that is known as the General Clauses Act 1897. So if you have not read General Clauses Act, please read that. Please have that in your library also. And in any case, friends, I think you are aware, but I'm telling you once again that if you have to download any statute, because nowadays probably we're not taking the books for the bare acts, right? Of course, I believe in I belong to a conservative old school. I always buy books for the bare acts. But now most of the people are downloading it in PDF format. I also download many times. It's not that I don't do that. But I love reading in, on the paper format. So if you have to download, can somebody tell me what is the best source of downloading? Because what we do is, if we have to search for General Clauses Act, we'll write in Google, and the first, the link which comes, we'll click it and download it. Don't do that. If you do that, you're going to make a mistake. Why? Because number one, it may not be the correct version. It may not be the amended version. So you will not get the latest version. So what is the best source of downloading any Indian statute or law is indiacode.nic.in. Please remember this, indiacode.nic.in. This is a website of the Government of India. You want to find out Companies Act, just write down Companies Act in the search bar. You will get Companies Act 2013. Click that. You can download PDF version, which will be the latest one, along with the rules, regulations, everything you will find. This is an excellent website. Don't go on vakil.com or whatever .coms are there. Forget about them. indiacode.nic.in. Please use this. This is an excellent source of material for the genuine, statutes for India. Okay. So please do that. So now, since I mentioned General Clauses Act, I'll request you to download from this website only and read this General Clauses Act. It will give you a lot of meanings. Like in all our laws, we use the word he, him, his, isn't it? We never use the word she or her. In most of the laws, in fact, in none of the laws you'll find that. So whether the masculine gender includes the feminine gender or not, the answer is yes, we know that. But from where it is coming? Where it is written? It is not written in every law. It is written in General Clauses Act. So please read General Clauses Act, which will definitely come to your help at many, many places, isn't it? So that's very important. Now coming back to the interpretation. Now please tell me, let's have a small debate on this. Or let's have some pointers from our friends. Why do you need to interpret the law? What is the need for interpretation? Can somebody contribute? Why do you need to interpret the law? Anyone who wants to contribute on this?
Because each one's perspective will be different depending on their understanding and take on what they've read about the law.
Okay.
The
So
interpretation of each can be different.
So what is the meaning of the whole sentence which you have said? The meaning is that we want to know the actual meaning of the word, isn't
Exactly.
it?
Yeah.
So आपके इतने लंबे sentence को I've shortened it, isn't it?
Yes, sir.
To know the actual meaning of the phrase or the word which has been used in law. So that is one. Okay. Yes. What else? What could be the possible things? Because there could be a multiple meaning of the word, isn't it? Like I use the word cold. Don't you think it has multiple meanings?
The intention of the legislature is also important.
Yes, intention. To find out intention is, of course, the most important thing, no doubt about it. But then there could be, and you see, there is a multiple meaning of the word. Like I mentioned cold. I've got cold. It is very cold outside. Two different meanings, isn't it? One single word. So whatever, in what context the word has been used. So please mark my words. The need for interpretation means that the text and the context must match. And this is a legal principle, that the text has been used in what context. This is very, very important, right? Intent and the content, or text and context, whatever you may say. So we will find out the intention of the legislature from the text itself. We do not need to interpret in any other things, isn't it? So this is also one of them. Then there is an ambiguity sometimes. As I always do this small exercise, let's do one exercise. Now, everyone, I believe everyone knows everyone has heard about the word vehicle, right? I believe everyone has heard about the word vehicle, right? Everyone knows the meaning. Okay. It's a very simple English dictionary word, vehicle. Now, friends, I'm going to give you certain examples of the word vehicle. If you feel it is a vehicle, right? Just write Y in the chat box. Yes. If you feel it is not, write no or N, right? Y or N. Okay, let's do it simply. Be very fast so that I know. Will you include a car in vehicle? Just write Y or N. Okay. Oh, Mr. Chatterjee says no. Rest everyone is saying yes. Okay. Okay. We'll come to Mr. Chatterjee. Why he's saying no? Okay. So will you include a bus in it? Okay. So everyone says yes. Okay. Let me make it a little more complicated. Will you include a train in it? Okay. 3 no's are there. Okay. 4 no's. Wow. So train will not be included. Anyone thinks that train should be included in vehicle? Okay. Sujata ji says we'll look at the other words. Okay. Okay. Will you include an aeroplane in it? I mean, I'll be very happy if everyone answers it so that at least we know what is what. Okay. Mr. Srinivas says yes. Okay. Yeah. Okay. Yes. Yes. No. No. Yes. Okay. Okay. Will you include a ship in it or boat in it? Okay. So friends, look at this now. a simple English dictionary word vehicle. Everyone said we know the meaning. But I gave first two examples. Everyone said yes, except for one gentleman. But for others, there are no, yes, no, yes, yes. So therefore, friends, this is a very important. Now, Mr. Sanjeev Kumar Arora says special purpose vehicle also. I know. I was thinking that this is also coming now. Well, as professionals, as chartered accountants, as company secretaries, as cost accountants, we deal with special purpose vehicle, isn't it? Okay. So all I'm saying is that there was a confusion because we did not have the definition, isn't it? It was only simple word. Now, if we create a definition, then naturally the confusion will be little less. So let's try to form. We are all professionals. Let's try to frame the definition of the word vehicle. Okay, how will you start? What will be just write down in the chat box what you think will be called as a vehicle. Let's go one by one. Let's value add to the others. How will you define vehicle? Supposing your daughter and son ask you, mom and dad, what is the meaning of the word vehicle? How will you define that to him or her? Okay. How will you say what is vehicle? Okay. I mean, you can unmute yourself also and say if you want to say or you want to write. Okay. So Datta writes a thing which carries people or goods from one place to other. Okay. And somebody has value added, it says means of transportation. Okay. Mode of transport from place A to B. Mode of transport which may carry passengers from one place to another. Okay. Okay. So therefore, let's you see consolidate for all these suggestions. It is a means of transport for carrying goods or people from one place to another. I think that will be the best definition which we can get it, right? Isn't it? Okay. So let's create that definition. Now, having created this definition, now look at the words which I used earlier. So will you include a bus in it? The answer is yes. Car, yes. Train, yes. Boat, yes. Aeroplane, yes. Because now it's a mode of transport carrying people or passenger from one place to another. We don't want to restrict it to, to land or sea, but it can be air also. So therefore, vehicle is a very broad term. Now, having decided this definition, friends, now I'm going to give you two more examples. And please tell me whether you will include them in the word vehicle or not. The first example is a bicycle. Will you include bicycle in the definition of the word vehicle?
Yes.
Okay. Now everyone is clear because now the definition is with us, isn't it? Okay. Second example. Will you include a bullock cart in it? Well, again, the answer seems to be simple. Yes. Okay. Now the third example. Okay. Little complicated. Will you include roller skates in it? Okay. One no has already come. Second no. Okay. Third no. Yes. So despite the fact that we created a definition, now still there is a confusion. Now, I'm not going into what is vehicle or not, whether we created a correct definition or not. Idea, all I'm trying to say is that even after defining it, we still have confusion. We still need to interpret. Now, if I ask the people why they have said no, they will have their own interpretation. If I ask the people who have said yes, they will have their own interpretation. Now, what interpretation is valid? Friends, mark my words here. Now, this is extremely important. Your interpretation and my interpretation or court's interpretation does not matter. What matters? What matters, my dear friends, if you want to note it down, write down, and please do always try to do that reasonable interpretation. You should interpret in a reasonable manner as an ordinary prudent person would do in such circumstances. What the law says, what the law means. I mean, we have to interpret in the context. Out of context, the meaning can change. So therefore, it is extremely important. Then there comes, you see, the rules of interpretation. I'm not going to deal with many rules of interpretation, but first I'm dealing with the literal interpretation rule. Now, this rule is known as read the law as it is. Don't try to interpret. Just read what is written in a pure, simple English language. Try to understand the meaning. I think most of the time, 80% you will understand. There is no need for interpretation in almost 80 to 90% of the cases. But supposing, now then there comes the golden rule. If the literal rule leads to absurdity, if the literal rule leads to ambiguity, then start applying the rules of interpretation. Otherwise, pehle se hi mat usko interpret karna shuru karo. So that is known as the golden rule of interpretation, right? Now, the third rule of interpretation. The third rule of interpretation is, there are different rules. What we call it as the mischief law, right? Mischief rule, or what we call it as Hayden's law. This was done in a Hayden's case, Hayden, Hayden's case, mischief law. Now, and this mischief law, my dear friends, mischief law interpretation was applied by Justice Nariman in IBC itself. Do you remember which case? He applied mischief law, mischief rule in ArcelorMittal versus Satish Kumar Gupta's case. You remember that 29A was brought in on the statute books, and this was brought in by a way of an amendment in 2017. 23/11/2017 ordinance was issued. Now, what does 29A say? Let us try to understand. 29A is in a negative form. Persons who are not eligible to file resolution plan, right? So it starts with a negative way, that the person and the person who is acting jointly or acting in concert shall not be eligible to file a resolution plan if, then there are several clauses are there, right? A to I clauses are there. Now, the question was before the court was because the constitutional validity of 29A was challenged. That was challenged in Swiss Ribbon also. So Swiss Ribbon and ArcelorMittal, if you read these two, mischief law was applied. So what Justice Nariman said, now what is mischief law? Let us try to understand that. You have to get answers to 3 questions. The first question is, what was the law before? Question number 2, what was the mischief that was sought to be plugged? And 3, how that mischief has been plugged, that means what is the new law? So what was the old law? What was the mischief? And how that mischief was plugged, that means the new law. So if you get proper answers to this, then you will say new law sustains. Otherwise, new law is not required, isn't it? So what Justice Nariman said that, look, the law before 2017 was that everyone was eligible, including the promoters. Even those people who have NPA accounts, who have defaulted, who are unqualified as directors, everyone was eligible to file the resolution plan. But this was a mischief, right? Now, this was a mischief which happened in the first case decided by the Honorable NCLT, first resolution plan which was decided by Hyderabad bench. Now, in that case, some mischief had happened. So to plug that mischief, because what had happened was the company of the promoters, which had given loan to this company, had assigned that loan to some non-related party, and then they submitted the resolution plan, and that resolution plan was approved. And do you remember what was the haircut in the first case? 95%. First plan which was approved by Hyderabad bench in IBC, there was a 95% haircut. Well, at the end of the day, the plan was challenged and ultimately the plan was approved. That's all right, because they never wanted to fail the first, decision. But the government actually took notice that the promoters are manipulating. So therefore, they brought in 29A to plug the loophole. And the Minister of Finance at that particular time, Mr. Arun Jaitley, he made a statement in the Parliament while introducing this bill 29A. And he said that we are trying to plug a loophole where the promoters are entering the company through a back door. They are responsible for bringing the company to insolvency first, and then they are buying their own company at a heavy discount. Well, this cannot be permitted. This is a mischief. So therefore, Justice Nariman looked at the statement made by the minister, the purpose of bringing that law, and the discussion and the recommendation of the committee also. And then he said, this is the mischief which has been sought to be plugged, and this has been done in the new amendment. So therefore, this amendment is absolutely valid. So mischief law was applied for interpretation of this. So this is an extremely good case. The other case is, you see, which I can give you the rule of interpretation, is the rule of jusdem honore.
Sir, what was the case name of this case?
ArcelorMittal versus Satish Kumar Gupta and Swiss Ribbon. आप दोनों पढ़ लीजिए, दोनों में 29 है.
ये first case of Hyderabad NCLT, sir. I am asking for that.
Synergies दूरे वाला, sir.
What, sir?
Synergies Dures Automotive. Synergies बोल लो. Synergies Automotive. Dure Automotive. DOORAY. Okay.
DOORAY.
Synergies Dure Automotive. पहला केस है हैदराबाद का. बहुत कंट्रोवर्सी हुई थी और इसी के चक्कर में आप बिकॉज ऑफ दिस केस 29 ए लाया गया. ओके. नाउ let us go to the other rule of interpretation, which is jusdem honore. इसको हम इंडियन इंग्लिश में jusdem generis भी बोल सकते हैं, right? Typically, as Indians, we use that language, jusdem generis, but it is pronounced as jusdem honore. Okay, anyhow, whatever, whether it is said what this or that does not matter. Now, what does this law say? This interpretation, rule of interpretation says, okay, let me give you an example. If I ask my wife to go to the market and buy bread, butter, eggs, cornflakes, and anything she likes, can she buy a jewelry for her? Or can she buy a wonderful dress for her?
Absolutely no.
तामरा साहब, आप बोल तो रहे हैं नो, आप बताएं पहले मैरिड हैं कि नहीं है?
Good, sir. Good satire.
You are going to be in difficulty, sir, if your wife is hearing this. Anyhow, I mean, in a lighter vein, I mentioned that. But at the end of the day, please understand. Now, if I tell this thing, of course, today women are independent. They don't require anything, and they don't require any permission from their husbands also. But this is just a way to explain it. So if somebody says, please buy bread, butter, cornflakes, eggs, and anything you like, means anything to eat, anything for breakfast, right? So what does this mean? This means that if general words follow the specific words, now they will also take the same color. This is the meaning of jusdem honore. So if the general words follow these specific words, they will also take the same color. And then, of course, we have got a beneficial construction. Interpretation rule is there, beneficial construction. Now, beneficial construction is very simple to understand. If two interpretations are possible, naturally, sometimes law is interpreted in two ways, isn't it? The one which favors the SSC will be adopted. So this is generally a rule which applies in, say, revenue laws and criminal laws. Like, I'll give you an example. All of us are aware that police requires a warrant from the magistrate to search any premises. And similar is the case with the income tax authorities or GST authorities. They need permission from their higher authorities. They can't just barge into your home, right? They must have some documentary evidence. So police requires a search warrant, isn't it? So one day what happened? The police party came to one person's home and they said, sir, we want to search your premises. That gentleman said, show me the warrant. So they showed him the warrant. And once the warrant was showed, and then he said, yes, you can search the premises. So the search party, you see, completed this search, you see, by 11:30 p.m. and went back. Next day morning, 7 a.m., again, they knocked the door and they said, sir, we want to search the premises. The gentleman asked, he says, show me the search warrant. And the police party showed the same search warrant which they showed yesterday. So the gentleman said, this is yesterday's, show me today's. ये तो कल का है, आज का दिखाओ. Now, the law does not say which date. Law simply says that the police requires a search warrant. Date kahan likhi hai law ke andar. So this is known as purposive ambiguity. Sometimes ambiguity is left by the legislature to be decided by the courts. So now there were two interpretations which were possible because the matter ultimately went to the Supreme Court. And the Supreme Court had to decide either this way or that way. Both the interpretations were possible. One, that once you go back after 12 a.m., then you require another search warrant. This interpretation is also possible. Another is, no, the law simply says search warrant is required, so a warrant can be of any date. But they decided that if we decide in favor of the police, then police will harass the citizens of the country. So therefore, they decided in favor of the citizens of the country. So if two interpretations are possible, typically speaking, in a criminal law and in the revenue law, like in income tax also, if two interpretations are possible, the court always leans in favor of the SSC and not in favor of the department. So this is what it is known as beneficial construction. And then, of course, probably you have heard about harmonious construction. Now, if two provisions are there in IBC, if they are contradictory to each other, then what should be done? I can give you two examples, right? I can't give you in detail, but I'll just give you two examples. Please read them and try to interpret. Section 14, moratorium, says that it prohibits institution of suits or continuation of pending suits or proceedings against the corporate debtor. Right? Everyone is aware, 14(1)(a), against the corporate debtor. So therefore, RP can still file because it is by the corporate debtor. That is our understanding. Okay. Now the question that arises is that supposing, and every case which is to be filed, it has to be within the limitation period. It has to follow the law of limitation, isn't it? And typically speaking, say, supposing some money is to be recovered by the corporate debtor from another person. So naturally, the case has to be filed within 3 years, right? 3 years is the limit for the recovery of money. Let us take an example. The money became due to the corporate debtor, say on 1/1/2019, 1st January 2019, right? The company came into CIRP on 1/1/2021. Now, looking at the law of limitation, my dear friends, till what time the RP must file this recovery suit? Obviously, one more year because 3 years are there. So 3 years will start from 1/1/2019 and they will end on 1st January 2022. So RP gets almost 1 year from 1/1/2021 to 1/1/2022, right? But if you read section 60 subsection 6 of IBC, 60 subsection 6, read that at your own pleasure, my dear friends. And please, after that, please try to conclude whether RP can file after 1/1/2022 also, or still he has to file within this time, because there is a contradiction now between section 14(1)(a) and section 60 subsection 6. So please read it at your pleasure and try to resolve that controversy by using harmonious construction. Okay. And the second controversy or contradiction I can show you is between section 60 subsection 2 and 3, 60 subsection 2, 60 subsection 3, read it with section 243 subsection 2, 243 subsection 2. There is inconsistency. So now try to resolve that inconsistency using harmonious construction. So we don't have enough time, otherwise we would have done that exercise, but please try to do that. That will be good. Okay. Okay, Trishla, tell me how much time is left, because then if I have exceeded my time, then...
Sir, it's 12:40 right now.
Okay.
Session has to end by 2 o'clock. So we have like 1 hour 20 minutes.
Acha, we still have good enough time.
Yes.
Okay, that is great, right? Okay, all right. Okay, was it 3 hours or 4 hours? 4 hours.
4 hours. 4 hours.
Acha, okay. All right. Okay. So, so we have got sufficient time. So friends, now this is one of the interesting things which you must try to resolve. These controversies must be resolved. Now, friends, let me take you to another, judgment also under IBC, which is also very interesting, where certain, interpretation rules have been applied. Okay, how many of you are here who have done law or something? I mean, who are LLB graduates or practicing as lawyers? Are there anyone who have done that? Or most of?
So we have advocates.
Acha, you have advocates.
Yes.
So those, if advocates are here, so probably they must have heard about jurisprudence. And those who are not, I'm introducing them to the concept of jurisprudence. Now, jurisprudence, my dear friends, is a legal word, which is a combination of two words, legal plus jurisprudence, legal plus prudence, right? Legal, juris plus prudence. Juris means legal and prudence means wisdom. So wisdom of law. How a law has been created, there is always a wisdom behind it. Now, to understand the wisdom of law, my dear friends, we need to really go behind the law and understand its jurisprudence. Criminal law has got criminal jurisprudence. Say insolvency law has different jurisprudence behind it. Corporate law has different jurisprudence. Income tax has different jurisprudence. Now, the jurisprudence behind income tax, let's try to understand. Because at the end of the day, the government needs revenue or money. So it says that you are supposed to pay income tax on your income, and some income is treated as income despite the fact it may not be income in the normal sense, in this normal standard. It is known as deemed income, isn't it? The tax authorities say, oh, it is a deemed income. Or in service tax also, it was treated as a deemed service, isn't it? So we are all aware about that. So what happens in income tax jurisprudence? Income tax is a law, friends, which has got strict jurisprudence. Now, strict interpretation. Strict interpretation means what? Even if you do not have money in your pocket, now you cannot say that I will not pay income tax. It is a strict law. Everyone is supposed to pay if you have the income. Right? So this is the jurisprudence behind the income tax. Now, how will you get to know about the jurisprudence? Now, that is also very important. Friends, may I request everyone to please mute their mics? There are some background noises which are coming.
Sir, I have muted them.
Okay, thank you. So, jurisprudence is very important. So, friends, please tell me, if you have to look at the jurisprudence of IBC, now where you will look at, what are the sources of jurisprudence for IBC? Please tell me. I think you have gone through IBC. So please tell me where you will find jurisprudence of IBC. What are the sources of jurisprudence?
NRC committee report.
Yes, sir. First is absolutely. I think I'll request one of our friends to write in the chat box. Bankruptcy Law Reforms Committee, or BLRC report. I don't know how many have read it, but please read it if you have not read it so far. Right? Download it from IBBI's website. It is one of the fantastic reports written in a very simple and easy and understandable language. I have not seen any report which has been written in an understandable manner than this report. So please read it, my dear friends. This is my humble request to you, right? And just now I mentioned that in most of the laws, we use the word he, him, or his, isn't it? If you read this report, the chairperson, Dr. Vishwanathan, has used the word she and her. He has not used the word he or him or his in this entire report. So there is a change in the mindset. So even for this simple reason, please read it. Okay. So it's a good report to be read. So first is Bankruptcy Law Reforms Committee report. Yes. Mr. Ramesh says winding up provisions under Companies Act. Yes, that's a good source, no doubt about it. Okay, what are the other sources? Please tell me, sir. Third would be Insolvency and Bankruptcy Bill of 2015. When the bill is introduced, it is introduced with some explanation. There are notes on clauses are there, isn't it? So notes on clauses are also very important in a bill which is introduced. So please go through them to understand the meaning of that particular section. That will give you an insight. The fourth would be the parliamentary debates. When this bill was being debated in the parliament, lot of discussion took place. So parliamentary debates are also important. In fact, I must tell you, this is very interesting, and this must be news for some people. When this bill was introduced, this bill was referred to Standing Committee of Parliament, which is a normal procedure because it used to happen that it is referred to a Standing Committee of Parliament, and in a Standing Committee of Parliament, opposition leader is the chairperson of that committee. And they actually invite comments and suggestions, and then they suggest that, look, these are the changes you must make in the bill before it is passed as an act. So the Standing Committee of Parliament debated it a very, very detailed manner. Now, let me tell you 2-3 things which happened. One of the provisions in the insolvency bill was that an IP, insolvency professional who is appointed, and before he is given any assignment, he will furnish a bank guarantee. This was the provision in the IBC bill. Can you believe this? The Parliamentary Standing Committee, and generally we say Parliament does not work, but they actually worked in your favor. They said, please delete this clause, because if you don't delete this section, nobody will accept the assignment. Who is going to accept an assignment if you ask for a bank guarantee? So therefore, this provision was deleted. There was one section, my dear friend, which was deleted on this. Can you believe this? And the second one was, which change which has happened is the PF controversy, which you are seeing nowadays, isn't it? Whether provident fund dues have to be paid in the topmost priority, whether they are part of the liquidation estate or not. This is the controversy which is going on. Ultimately, it will be settled by the Supreme Court. It has not been settled so far. But anyhow, how this controversy started, you must understand the background of it. There was no provision like section 36, subsection 4, clause number 3. There was no provision of that for the provident fund. That means liquidation estate will not consist of the provident fund and gratuity fund and so and so fund. 3 funds are written there. This sentence was not there in the original insolvency and bankruptcy bill. Now, how this provision came into bill or came into the act? The PF department made a representation before the Standing Committee of Parliament. They said, look, provident fund dues are very important for an individual. So these funds should be kept separate and no one should be allowed to take it forward, take it away. So everyone should be allowed to retain that. This was what the idea was. Okay. So what they did, and they actually mentioned it in the context of individual bankruptcy. Because when an individual is declared as a bankrupt, they said whatever money is due to that person on account of provident fund, now that should not be taken away by the bankruptcy trustee. So it should be, because it is a security, kind of life security kind of a thing. And the Standing Committee of Parliament agreed with this. They said, yes, we agree with you. So if you look at the provisions of individual bankruptcy, it is not included, it is treated as an excluded asset, right? Of course, it is not mentioned in the excluded asset definition, but if you look at the later parts of the section, when the bankruptcy trustee takes over, he cannot take over the provident fund amount, which is, paid to the particular individual. So that is out. Now, from the point of view of an individual, it is an asset for the individual. So they said it should not form part of the assets which should be taken over by the trustee. Fine. But the same logic was applied in section 36. And clause 36.4.3 was added, that liquidation estate will not consist of the provident fund and the gratuity fund and annuity fund, pension fund. 3 funds are mentioned there. Nobody realized, please understand friends, nobody realized that amount which is payable to the employees on account of provident fund or gratuity fund is not an asset for the corporate debtor, it is a liability. See, from the individual's point of view, it is his asset. Fine, you will not include in that asset part. It is excluded asset. But insofar as the corporate debtor is concerned, how it is an asset, please tell me. It is to be paid to the employee. It is a liability for the corporate debtor. So why everyone is interpreting that this will not form part of the liquidation estate when it is a liability? Today, there are judgments of NCLT and NCLAT. They're saying, no, this amount will not form part of the liquidation estate. Did anyone try to tell them, sir, this is a liability? This is not an asset of the corporate debtor. Unfortunately, the statement of the Provident Fund was applied in part 2 as well as in part 3 without application of mind. For part 3, I agree, it is an asset of the individual. But for in part 2, how it is a liquidation estate? So therefore, all I'm saying is the confusion definitely arises because of sometimes the interpretation is also there. So parliamentary committee debates, if you look at it, I mean, the report is also very important to understand the jurisprudence behind the IBC. And then the last point, the preamble of IBC. If you look at the IBC initially, for what purpose the IBC has been brought in, the preamble says so. The preamble also gives you an insight on the jurisprudence behind the IBC, right? It is an act to amend and consolidate laws relating to reorganization and insolvency resolution of the corporate debtor, corporate persons, and individuals. Isn't it? In order to, in a time-bound manner for maximization of value of the assets of the corporate debtor. And then, of course, in the second term, it says you see, entrepreneur to enhance the entrepreneurship and to make availability of the credit. And then it also says to balance the interest of the stakeholders by altering the order of priority of payment of the government dues. So these are the things which are written in preamble. So this is the jurisprudence. Now, having explained what is jurisprudence and how do you find it, now, friends, there are many theories of jurisprudence. I'm not going to deal with too many. But first, I would like to mention about the Austin. Austin is considered as father of jurisprudence. Those who have not read, please read Austin's theory. That's very important. And one thing I can guarantee you, friends, if you are insomniac, that means you're not able to sleep properly, start reading Austin's theory of jurisprudence. I can guarantee you after reading 2 pages, you will sleep merrily. Right? आपको नींद बहुत अच्छी आएगी jurisprudence की कोई भी theory पढ़ने से. So anyhow, besides that, Austin, you see, gave us, somebody asked him a question and he was also trying to understand what is law. So Austin said that law is a combination of CDS. C stands for command, D stands for duty, S stands for sanction, CDS, command, duty, sanction. He says law is a general command of the sovereign to be followed by the citizens. And if they don't follow, then there will be a sanction. So he says law includes 3 parts: command, duty, and sanction. There is a direction, there is a command coming from above. Then it is the duty of the citizens to follow. And if they do not follow, then there will be a sanction. And he took an example of red signal. He says stop at a red signal is a command and it must be followed by the citizens. And if they don't stop, then the challan will be given to them. Now, after this theorist, jurist, then another jurist came into the scene. His name is Professor H.L.A. Hart. Professor H.L.A. Hart. Hart is H-A-R-T, not other Hart. Okay. So now, Professor Hart says he also developed the theory of jurisprudence of law and tried to improvise on Austin's theory. He said law, Austin says it is command, duty, and sanction. He said law is only a combination of duties. He said there is no command in the law. And he also said sanction is not mandatory for every law. Because all of us know if we violate Companies Act, we are liable. If we violate IBC, we are liable. So there is always a sanction. There is always a deterrent factor. But Professor Hart said it is only a combination of duties. There is no command. And even sanction can also be excluded. He also improvised or took the, you can say example of Austin of red signal. He says to stop at a red signal is the primary duty of the citizen to do so. Look at this. This is very interesting. To stop at a red signal is the primary duty of the citizen to do so. And if it does not stop, it is the secondary duty of the traffic policeman to give him a challan. He says, where is the command? It is only a combination of the duties. First duty is imposed on the citizens, and if they don't comply, then the second duty is on the authorities to comply with it. So he says, where is the question of command here? So this is, he improvised on that theory. And he also gave an example of certain laws where there is no sanction. Friends, can you think of any law where there is no sanction? Like in Companies Act, there is sanction. Income tax, there is sanction. IBC, GST. Can you think of any law where there are no sanctions? Okay, let me give you an example. Law of wills. If I don't make a will law penalize me? Law of marriages. If I don't marry, will law penalize me? So there are certain social laws, right? So social laws for the society which they are made for the benefit of the society. So he also gave that example. Now the third theory which I'm mentioning, I'm not boring you, but I'm trying to give you another perspective on which there is a judgment of High Court. And that theory is Kelson's pure theory of law. Now Kelson came out with a pure theory of law, and on which there is a judgment of Kolkata High Court. Now Kelson said that, look, he created a concept of a basic fundamental law, right? That is what he tried to create, that there is a law which is above everyone. Now that is extremely important, that how we look at that, okay? And he, devised a concept of Grundnorm. That is, he was a German jurist. This is a German word, Grundnorm. Grundnorm is a basic norm. He says there is a pyramid of the laws. Every law or this thing flows from something or the other. So friends, IBC, please tell me, IBC flows from which basic law? What is the basic norm in India? What is the Grundnorm in India? Naturally, the Constitution of India, isn't it? So every law must be constitutional. That means it must be within the four corners of the Constitution of India. So Constitution of India is the Grundnorm in India, and rest all are the pyramids. So he said the laws are pyramids. Now this theory was applied to interpret a provision under IBC. Now friends, let me introduce you to that judgment also. And what happened? This is very interesting. In July 2020, during COVID period, the principal bench, the president of the NCLT, issued a circular. I mean, whether it is a circular or it is an order, we don't know. It is order. It is the word which is written is order or notice. I don't know, whatever it is written. So it said that any application which is made under Section 7 by a financial creditor must accompany with a certificate from the information utility, must accompany with the evidence of the information utility. If that evidence is not attached along with the application, then the application will be dismissed. So this was the order which was made. And in the same breath, in the second sentence, he wrote that any application which is already filed under Section 7 must also comply with this. And if they do not comply with this, then their application will be dismissed. So that means no fresh application will be considered. And even the pending application, they will have to comply with this provision. Now, this order or notice or whatever you may call it, this was challenged before Calcutta High Court, right? And the name of the judgment is Univalue. So those who have passed limited insolvency recently, probably it was in their syllabus. Those who have not, you can get hold of that judgment, Univalue. Now, in that judgment, two persons, you see, went to Calcutta High Court. Number one person said that, look, my application is already pending before the adjudicating authority, and suddenly this order has come. Now, how can this order be retrospective in nature? I am not supposed to comply with this. Number two, the person and the second person he challenged, he said, look, my application was ready. I was about to file that application, but suddenly this notice has come, and this is bad in law because of these reasons. So the court had to consider whether this order which has been issued by NCLT president, whether it is valid or not. The judge in that judgment, and you must read that judgment, my dear friends, and the judge applied the Kelson's theory of law. Jurisprudence theory, that has been applied in that judgment, and you must read that. That's a very interesting judgment to that extent. And the judge says that there is a pyramid or hierarchy of, law. So he said, on the top, it is the Constitution of India. Then comes the law which is framed by the Parliament. Then underneath comes the rules or regulations framed, which we also mentioned just now, in the beginning, as delegated legislation. Now, he said that, look, rules or regulations cannot contradict the law, and the law cannot contradict the Constitution of India. So this is the hierarchy, and this is the pyramid. And he used Kelson's pure theory of law. Now, he analyzed that let us try to understand this order or notice issued by NCLT president, whether it falls under which hierarchy. So he actually looked at NCLT rules. He said, let me see under which rule this order has been issued. When he scanned the entire NCLT rules, the judge was not able to find out under which rule this order or notice has been issued. Then he presumed, my friends will recall, if you read Rule 11 of NCLT rules, it says inherent power of the bench, inherent power, right? Inherent powers of the adjudicating authority. That means in the interest of justice, they can pass any order. He says, I am presuming that the bench has issued, that the president has issued this notice exercising Rule 11 of NCLT rules. He says, I'm not clear, but I'm presuming. Now, having said that, he said, now let me understand, when the order is been issued, now this order, can it violate the rules? Can it violate the law? Or can it violate the Constitution of India? And when he looked at Section 7, my dear friends, Section 7, subsection 3, what does it say? That along with the application, you need to attach these documents. What are those documents? The documents are the evidence from the information utility, evidence of default from the information utility, or any other evidence in support of the default. So he said, if the word or is used in section 7, then you have the option either to attach the information utility information, that means the information of default, or you can prove it by other documents. So it is not mandatory. So law does not make it mandatory. How can this order by the president can make it mandatory? So this is violative of it. And even he looked at the form also. In form also, there were various options which were given. So he said, sorry, it is not mandatory. So therefore, this order is bad in law. So then that order was quashed by Calcutta High Court. So this is where the controversy arises, and then these principles of jurisprudence are also applied. So reading these theories, my dear friends, is not simply theoretical, but it is also has some practical touch to it. So please go through these jurisprudence theories. There are 4 jurists which I can recommend you: Austin, Professor Hart, Kelson, and Hoffields. So Hoffield is also there. So please read if you are able to read these 4 theories at least. Okay. And they will make a very interesting reading for you. Now, having said that, friends, now let us look at the very interesting part of it. And that is how to appear before the, adjudicating authority or NCLT. Now, that is also very, very important. But before that, let me give you, you can say an overview of principles of natural justice. Okay. Let me see if I can, principles of natural justice. Now, supposing, friends, I ask you to explain what are the principles of natural justice. What is required? Okay, Mr. Sirinivasa is saying, sir, can you ask your question, sir? Can you unmute yourself and can you ask your question? It is better rather than my reading the whole 10 sentences. If you can just put your question, I think that will be better.
Yeah. Good afternoon, everybody. This is Srinivasa. So the recent judgment last week, the Hyderabad bench, NCLT bench has given a judgment in one of the liquidation cases. I just give the brief. The CD was stopped operation since 1/8/2017. Under Section 10, the company CD itself has gone for CRIP, and admission order was passed on 8/9/2019. And since the relationship has not approved by the COC, the liquidation order was passed on 21/4/2021. The workers have submitted their claims under liquidation, and based on the liquidator has admitted only to the extent of 20% of the total claim. And the workers has gone to AA for the admission of unadmitted claim as well as the make payment. In the judgment, the NCLT AA has directed liquidator to make payment of wages from starting of the, that is 1/8/2007, starting of the operations till the liquidation date, along with the retrenchment compensation, gratuity, etc., etc. So this is almost coming to around 16 crores. And he is asking us to make payment as a CRP cost, not under 53(1)(a). So it is very, since all the amount sale proceeds of entire thing has been dispersed to the stakeholders. And as on today, there is not much funds are available with liquidator to honor the order of the NCLT. So in this case, I just want to have views how to go about it.
Sir, the point is, you see, everything depends upon the facts of the case. Now, today, you see, what you are saying is that the workers' payments from the date of the starting of the ICD, the insolvency commencement date, what is that date?
Not insolvency commencement date, sir, not insolvency commencement. It is asking from the stopping of operation. That is 1/8/2017.
So 1/8/2017, their operations were stopped by the CD, right?
Yes, by the CD.
Started on 8/9/2019. Now, what the court says that court says that from 1/8/2017, you make payment of the wages to the workers.
Yes, sir.
Okay. And you don't have to make payment as per section 53(1)(a), but you have to make full payment to them first. That is what they are saying.
Yes, yes.
making
what
a
is their
part of CRP cost and making payment from 53(1)(a).
Okay, see, I have not read the judgment, but what you are telling me, according to me, this judgment is can be appealed because of a simple reason. Number one, the operations have been stopped. So if the operations have been stopped prior to the commencement of the CIRP, so therefore no one, was working. If no one was working, so therefore it can't form part of the CIRP cost, right? Because the operations were stopped and the operations were not started during CIRP also.
Correct.
So therefore, till the LCD, which is a liquidation commencement date, workers will have to file the claim. And once their claims are admitted to that amount, then they will be paid in proportion to whatever their value comes and as per 53(1)(a). Now, if the bench is telling you that you pay from 1/8 2017 till the date of liquidation, I believe this is not a very good judgment. So please go and file an appeal before the NCLAT. I think you have a greater chance of succeeding there.
Yeah, they have put it the Supreme Court order where it says if the workman worked and the company, the CD was operated, run by the operations of the CD were run by the resolution professional, then it can be considered as part of CRP cost. Whereas here, in this case, operations were stopped in the year 2017. Only thing is that termination was not done in accordance with the ID Act. That is the only flaw there.
No, all I'm saying is whether termination was done under the Industrial Dispute Act or not. See, that is a question which needs to be determined by the RP. So RP will get the claims from the workers. Now, whether he admits or not, then supposing you don't admit, they will go to the NCLT and ask for admission. That is a different issue. Assuming you admit, you admit full of their claims, right? Let us assume that.
Yeah.
But they can't be paid, you see, prior to anyone. They will be paid in proportion to the secured creditors.
Exactly.
So if they have been directed to pay, I mean, RP or liquidator has been directed to pay in priority, in super priority as a CIRP or liquidation cost, that is wrong. That's what I'm saying.
Yeah. In fact, see what happened, just a moment. In 1 second, I will complete that. They made a claim for the entire salary, including the salary till the LCD, liquidation commencement date. I admitted their claim up to the 2017 when the unit was closed with gratuity and all that. So partially the claim was admitted partially. And they made an application IA before the NCLT saying that their claim was not fully admitted and they sought direction to the liquidator to admit the entire claim. But surprisingly, the bench has given an order directing the liquidator to pay them under 53(a) and treating that as a liquidation cost. Though unit never worked, and in the IA, the workmen themselves confessed that, admitted that they were never allowed to enter the premises after the unit was closed. And it is a clear case that they never worked.
So therefore, if you are able to demonstrate that the operations were stopped and they did not work, despite the fact they were not terminated, so they are not entitled for that payment of the wages or something like that. So this you can mention that. And in case that is done, because you see, at the end of the day, let's understand, the courts in India are sympathetic to the workers. No doubt about it. On that.
Yes.
So the only thing is they say, oh, you did not terminate as per the Industrial Dispute Act. So therefore they continued, therefore they are entitled for salary. This is a logic which can also, you see, cut ice with the benches. But the only thing is, how can it be treated as a CIRP cost or a liquidation? It can't be.
Yes.
It can't be. So therefore, I think this has to be emphasized. So you go up to Supreme Court, sir. Don't get disheartened by any judgment of NCLT. Whenever any NCLT passes a judgment, I always take it with a pinch of salt.
Thank you.
So unless Supreme Court decides, you have got very fair chance to get it, this thing. Okay.
Thank you very much, sir. Thank you.
Okay, friends, I think many of us were asking about that Univalue judgment. So I have mentioned that name in the chat box. This is the Calcutta High Court Univalue Projects versus Union of India. Okay. So if you need the date of that judgment, I can also give you that. Okay, just let me see when it was passed. Yeah, it is 18th August 2020. That is 18th August 2020 judgment. Okay. Okay. Then Mr. Ramesh says, is it not correct that the person who filed before the order of the NCLT president was correct with respect to retrospective application of the order? Mr. Ramesh, you are absolutely right. That is one part of it. The second part is naturally, they said under which you see provision the order has been issued. So this order which has been issued is violative of these sections, section 7 particularly. So therefore, on that ground, you see it was mentioned. So the court did not go into the second ground of retrospective nature. Okay. Mr. Ramesh says, I have a question. Okay. Yes, sir. You don't seek my permission. Just go ahead, sir. Shoot your question.
Yes, sir. Good afternoon for the wonderful presentation.
Yeah.
My question is, you were mentioning something about inherent powers of the court.
Right.
And the NCLT in particular.
Right.
How far do the courts go to exercise this inherent power? And how do we as professionals, not only as an RP, just as a practicing professional, maybe CACS, how do we interpret this or understand this inherent powers of the court?
Okay.
Thank you.
Inherent powers of the court are already there in section 151 of CPC also, right? It is not that this is a new subject, it is an old subject. And this rule 11 was missing in company law board's regulations earlier. So when we drafted the rules, we created this rule 11, and you will also be surprised to note, rather is very interesting to note, rule 11 is same in NCLT rule and NCLAT rules. Coincidentally, it is ditto. Okay. So inherent powers of NCLT and NCLAT are contained in rule 11 in their respective rules. So rule number is same. Now, what is the meaning of the inherent powers? Inherent powers does not expand their powers. See, they have got powers to decide under different sections. So they have to decide within that parameter of law. They can't change and override the law under inherent powers. Please understand this. This is very important. Supposing the requirements of section 7 are not met, they can't say we are admitting under inherent powers. Now, one of the examples which I can give you, which is very interesting. Do you remember the case of K. Shashidhar by Supreme Court? K. Shashidhar versus Indian Overseas Bank, Supreme Court judgment. Now, what happened in that case?
No, sir.
I'll give you those facts because that was an early cases, 2017-18 cases. What happened in that case? There was a company in Hyderabad by the name Kaminini Steel and something by that name. And in that case, the resolution plan was approved by the Committee of Creditors by 74.25%. At that time, please remember, you required 75% majority. It was later on brought down to 66%. So I'm talking about prior to amendment. Okay. So earlier 75% majority of COC was required. So what the bench said that, look, despite the fact that it has been approved by a lower than the threshold limit, earlier the threshold limit was 75%, I am approving the plan. Adjudicating authority went ahead and approved the resolution plan under Rule 11 inherent powers in the interest of justice. They said otherwise employees will lose their jobs, the government will lose their revenue. This is such a big industry, it will lose its value and so and so. They wrote in public interest. So they use the word, we are using our inherent power in public interest. We are approving the resolution plan despite the fact that it is below the threshold limit. Similarly, now look at the second scenario. I believe you have also heard about the name of the company, Innovative Industries. I think nobody will forget Innovative because this was the first case under the IBC by Supreme Court, right? Innovative Industries versus ICICI Bank. Now that company's plan, when it came for the plan, it was also approved by 74 point some percentage, but less than 75. Mumbai bench of NCLT said, since it is less than the threshold limit of 75%, we are rejecting the plan. We have no powers. It has to be approved first by 75%, only then we can approve it. So both these cases were dealt by in case Shashidhar judgments. Both the appeals came before Supreme Court, and both these appeals were decided in a single common judgment of case Shashidhar. Now, what did the Supreme Court said? Supreme Court came down very harshly on Hyderabad bench. They said you cannot use your inherent power. You cannot use the word public interest and decide, because threshold limit must be crossed first. This is sacrosanct. This is mandatory. So 66% or 75, whatever it is there. So it has to be crossed first. So if a resolution plan is approved by less than 75%, you have no authority to change that dictum. Commercial wisdom is more important. This is where the judgment of commercial wisdom is coming. Commercial wisdom is supreme. It cannot be replaced with the judicial wisdom. So inherent powers cannot be used to replace the judicial wisdom with the commercial wisdom. So inherent powers are very limited powers. What are those powers? The powers are like, supposing I have made an application and I did not, after making the application, I did not appear for a single hearing and the judge dismissed it for non-appearance, for non-prosecution, dismissed for non-prosecution. This happens, probably you would have also seen it in some cases. Now I file an application for restoration of that application. Now under restoration, there is no provision under NCLT rules or IBC. So here I will file an application under Rule 11 and I will invoke the inherent powers of the bench that please restore my application to its original status. So there the inherent powers are used in the interest of justice. It is not causing any prejudice to anyone. So therefore they use the inherent power. Similarly, if there is a, you can say, order has been passed, some figures have been written wrongly, right? The name of the parties have been written wrongly. So you have to apply for the of course, there is a rectification of order. I think Rule 154 is there, but you can also use Rule 11 as an inherent power. That under inherent power, you can rectify your own orders. So this is what.
Sir, inherent powers are related with judicial powers only?
Obviously, so they are
Suppose I have a case.
Yeah.
Where the CD has paid the principal amount to the OC,
okay,
and OC has not given the settlement.
OC has
now NCLT has to intervene in this case anyhow.
No, I have not understood, sir. See, OC has filed a case against the CD, and
Yes.
CD has paid the principal amount to
principal.
OC. So we're not able to hear you, sir. Your voice is breaking actually. Mr. Ram Kripal Singh, we are not able.
The OC.
So just hang on. We were not able to hear you. There was a drag in your voice. We were not able to. Can you explain again, sir, quickly? Okay, I believe we have lost his voice once again. Okay.
Can I come in, Mr. Ashish?
Can you hear, sir? Can you hear?
Okay.
Yes, Mr. Ram Kripal, go ahead, sir.
Can you hear, sir?
Yes, sir. We can hear you now. Please go ahead. Okay.
I have some issues, sir.
Sir, I think you have some connection issues. Maybe what you can do is you can log out and log in. I think then you can, that will become better, sir. Okay. Yes, Mr. Ramesh, you can go ahead.
Yeah, can I? What I understood from what you said is that unless the provisions contained, express provisions contained in a particular act, specifically restrain court's powers, there is a blanket permission other than outside of that. Am I correct in understanding what you said?
No, I have not understood, sir, what you're trying to say.
Okay. I'll put it.
Can you elaborate?
I'll rephrase it. Yeah. From what I understood, the courts, while exercising their inherent powers, are governed by the provisions, express provisions of the law, literally. If there is no power, if there is no provision which restricts the court's power to use their wisdom in adjudicating, they are free to do so. Am I clear? In other words, there should be an express provision. They should be bound by four corners of the law before exercising the inherent powers.
Naturally, sir, because at the end of the day, you see, law is supreme. Now, inherent power, you see, they don't have power like Article 142 of the Constitution of India, which is vested with the Supreme Court. Article 142 says, in order to do complete justice between the parties, Supreme Court can pass any order. Right? So, and in many cases, Article 142 has been invoked in IBC. Under IBC also, it has been invoked almost 10 times. Various occasions, despite the fact there is no power. So Supreme Court can do so. High Court cannot do so. And even other courts cannot do so. So therefore, it is very important that inherent power has a very limited operation. Supposing there is an error in the order, which is to be corrected, they can use inherent power. Supposing they have given a time, say you file the reply within 15 days, you don't file. They can extend the time under inherent power. This is something where it is not causing any prejudice to anyone. This is just in the interest of justice. But they can't go beyond the law, provisions of the law. So one should understand that law is supreme. Inherent powers are to be exercised within those four corners of law only. That is
yes, sir, I understand. What if one of the parties to a litigation is actually prejudiced?
See, at the
or
end
if
of the
he's aggrieved,
no, see,
or if he's remediless under the law.
No. See, please understand. There can't be any order which will put like, you see, supposing somebody files a reply late and the court condones the delay and says, okay, yes, I condone the delay. Now, what is the prejudice which is caused to the opposite party? So therefore, he may be aggrieved that, oh, why did you allowed 15 days more time without putting any cost to him? He may be aggrieved. Aggrieved is something different. But at the end of the day, to administer the justice, to look at the real questions of law, unless the reply is taken on record, how will they decide the real controversy? Somebody can be delayed. They might not have attended one hearing. Their application is dismissed. He comes for restoration. How does it impact the opposite party? So in that sense, inherent power is to be used. But if inherent power is used where it goes beyond the law and it prejudices a party, then of course it is challengeable. It can be challenged. Just like you see, I gave you an example. COC approves it less than 75%. Obviously, then it is beyond the law. So the court came out very harshly on the adjudicating authority. He said, how can you do this? You're not entitled to do it. Okay. So friends, any more questions? Okay, I think Mr. Ram Kripal Sharma is writing. I have a case where CD has paid principal amount to OC. However, OC has not applied for withdrawal. How should NCLT decide? Okay. See, here there are two things, friends. As far as withdrawal is concerned, withdrawal of, you see, an application, section 12A comes into picture when the case is admitted. So therefore, here the withdrawal or not withdrawal does not impact. You, supposing somebody files a case against you, you are the corporate debtor, and you are able to prove to the court that you have paid the full amount. Say they are claiming 1 crore 10 lakh rupees and you say, I have already paid 1 crore 10 lakh, here is the proof. Naturally, even if it does not withdraw, his application will be dismissed. So therefore, withdrawal before the admission does not matter.
No, it has been admitted. CIRP is already admitted.
Now you say, now you are coming.
After CIRP, before formation of COC, he has given the full payment.
Sir, अब एक बात बताइए ना मुझे, if you have given the full payment after the CIRP commenced, so what the people who were making the payment, they were fool. I mean, they should have got the withdrawal application signed along. These papers are
वो
exchanged.
नहीं किया ना सर, वो नहीं किया, एनी हाउ नहीं
ये तो
किया।
फिर गलती है ना promoters की, boss.
हाँ, प्रमोटर की
Now
गलती,
they will
लेकिन
have to-
अब बट डिसाइड तो इसमें मैं ये जानना चाहता हूँ, इनहेरेंट पावर एनसीएलटी इसको है या नहीं
कर
है?
सकता है, कर सकता
वही
है,
पूछना
कर
चाहता
सकता है, but at the end of the day, you see, there can be a problem
हूँ,
because
because now एनसीएलटी has to decide what to do.
no, definitely they can look into this, because at the end of the day, idea is not to put the company into stress unnecessarily, which is this is the
Yes.
Supreme Court judgment also. Naturally,
Yes,
you will be advised to put it very strongly. But problem is, if the matter drags on for some more time, RP will form the COC, and then you will require the 90% approval of the COC. So there will be a problem later on.
Yes.
But right now, before the COC is formed, you should move immediately an application. Don't wait for him to now.
Yeah, I
file
have
a-
applied, sir. I have applied the application,
please
and
do it
2 dates.
immediately.
I have appeared for 2 dates.
And ask for a stay for the formation of the COC in the meantime. Please ask for that, because if the COC is formed, then you will be in trouble. Okay.
RP can also apply, sir, for not to form COC.
नहीं RP नहीं करेगा, RP क्यों करेगा? ये तो आपको
I am
करना
IRP of that case.
You will not do it. The promoters have to do it. Those who have said
Promoters have to do. Okay, they have done that. They have done that.
right. आपका क्या interest? आपका तो interest है CRP चले.
Yeah.
All right. Okay.
ठीक है, thank you, sir. Thank you for nice presentation, sir.
Okay. अभी presentation खत्म नहीं हुई, sir. Okay. Prajakta ji is saying, sir, can you speak about jurisprudence developed by Rainbow Paper and duty on liquidator if they have VAT claims? Okay. Friends, I think I've spoken enough on Rainbow Paper, but I can still speak on that. So let me deal with it if you want to hear about that. What Rainbow Paper is, let's try to understand. Rainbow Paper makes 2-3 statements, right? And I'll quote, you see, straight from the judgment also, what is the Rainbow Paper talks about. Number one, Rainbow Paper says that the VAT department, that is the Gujarat VAT, they were not supposed to file a claim. RP should have admitted the claim on the basis of the books of account or the information which is available with it. Now, this is exactly what the Rainbow Paper says. Number one, I'll deal with it one by one. Number two, timelines, and this issue was not before the Supreme Court, but they have decided, they have written in one paragraph or one sentence, which is very surprising. In a general way, they are saying timelines in IBC are directory. All timelines. They're not mandatory, they are directory. Now, this has a huge impact. But anyhow, why they gave it, will let us understand the background also. But let us mark this. This is the second ratio. I mean, these are the legal propositions which they have created. Third is that sales tax department, which is a VAT department, is a secured creditor. This is their third, you see, ratio or the legal proposition. And the fourth proposition is that if a resolution plan does not deal with the claim of the VAT or the sales tax department, then such a resolution plan is bound to be rejected by the adjudicating authority. So this is their fourth contention broadly. I mean, there are 7-8 contentions, but I'm giving you broad contentions which they have said. Let us deal one by one. Friends, first they say that the sales tax department was not required to file a claim before the RP, and RP was supposed to admit it without filing it on the basis of the books of account. Now, this statement of law or the legal proposition, friends, has to be taken with a pinch of salt. This statement of law does not apply to you. Why I'm saying so? The case of that particular, the particular case relates to an prior to amendment which happened in regulations on 4th July 2018. This is the case prior to 3rd July or 4th July 2018. Now, let me give you a background. What is the amendment? If you look at the regulations where the claims are to be filed by the operational creditors, financial creditors, and other creditors, other stakeholders, and then going up to regulation number 12 and 13 also. What was the phrase which was used prior to 3rd July 2018? This amendment came on 3rd July 2018 with effect from 4th July. So I may use both the dates, so don't get confused. So prior to 3rd or 4th of July 2018, all these regulations where the claims are to be filed, they use the phrase, every person, the operational creditor must file proof of claim with the RP. The word which was used was, please remember this word, proof of claim. It was mentioned in all those regulations, I think regulation 7, 8, 9, 10, 11. You read that, the word was proof of claim. This word, this phrase, proof of claim, was replaced with another 3 words, claim with proof. देखिए सर, words की interpretation कितनी जबरदस्त है. Proof of claim was replaced with claims with proof. Meaning ही change हो गया. Supreme Court has caught this. They said sales tax department was not supposed to file the claim because your regulations say so. RP should have admitted on the basis of the books of account, and if he is not satisfied with the books of account, then he might have asked for the proof of claim to be filed. Then the sales tax department would have filed the proof of claim, but they are not supposed to file the proof of claim just like that. And now after 4th July, they said the words have been changed to claim with proof. They say after 4th July, it is mandatory to file claim with proof. But prior to that, it was not. Poor drafting का आपने देखा सर कितना impact पड़ता. The regulations were very poorly drafted initially. Claim, proof of claim. What do you mean by proof of claim? In fact, when they were drafted, even I objected to that. I said, why are you using these words? You have to file a claim with proof, not proof of claim. So Supreme Court interpreted that prior to 3rd July 2018, they were not supposed to file the claim. They were only supposed to file a proof of claim if asked for. But this judgment or legal proposition does not apply to you because now that date is gone. So every claim now is filed after 4th July 2018. So therefore, forget about that interpretation. That is not applicable to you. So this means that whether it is a sales tax department or income tax department or VAT department or any damn government department or statutory dues, they are supposed to file the claim now. So if they say and rely upon rainbow, no, we are not supposed to file the claim, then tell them, sorry, that judgment is based on amendment prior to 3rd July 2018. After that, the law is amended, and that is a paragraph which is mentioned in the judgment itself. You can show that paragraph. I hope I'm clear on this. Okay. Now let us come down to the second thing. Timelines in IBC are directory and not mandatory. Now, friends, I told you interpretation, text and context must match. So I will read this judgment in context. So timeline with respect to filing of claim is not mandatory. So probably Supreme Court was trying to say that timeline relating to filing of claim is directory. But somehow or the other, a general line came, timelines in IBC are mandatory, are not mandatory. Well, this is not the correct interpretation. I will still interpret it to restrict it only to filing of claims, because the issue before the Supreme Court was only filing of the claim. How can they comment on everything? So therefore, I think this judgment should be seen in that context. This is my observation to that. Okay. But obviously this sentence definitely causes confusion, but I think we can explain to the benches that, look, this is the whole game there. Third, the Supreme Court said that sales tax department or VAT department under the Gujarat Value Added Tax Act 1948, they are the secured creditors. Now, why they are saying that? Let us try to understand. Section 48 of Gujarat VAT Act tax, it says that any claim of the sales tax department relating to tax, interest, or penalty. Three things can be there. Either it can be tax, interest, or penalty. It shall be the first charge over the assets of the person who is liable to pay, which is the dealer. Earlier, the word dealer was there, okay, under sales tax. So naturally, the company, corporate debtor. So what it does is that any outstanding tax, interest, or penalty, it creates a first charge over the assets of the corporate debtor. Supreme Court says, let us look at the definition of secured creditor in section 3, subsection 30, clause 30 of IBC. Secured creditor means a person who has security interest. And then 331 defines security interest. And security interest includes charge. So therefore, they have interpreted that it is a statutory charge created over the assets of the corporate debtor. There they hold security interest. Therefore, sales tax department is a secured creditor. To this extent, my dear friends, I agree with the Supreme Court judgment. There is no quarrel. Charge can be created either by a statute or by a contract. Company enters into a loan agreement with the bank, say SBI or any other bank, and bank creates a charge by way of an agreement. It is a contractual charge. Second charge can be by way of a statutory charge, which is created in VAT Tax Act. It is created in GST Act. It is also created in Customs Act. It is also created in excise laws. It is also created in PF Act. So naturally, and probably in other laws also. So there is no quarrel to this proposition that they are secured creditors. If now I'm coming to that. So if a VAT department or any government department, say property tax or any department comes to you as an RP and say, we are the secured creditors, you tell them, sorry, I will not consider you secured creditor unless you show me the provision in your law. They should have a similar provision which was contained in Gujarat VAT Act tax, that interest, tax and penalty shall be the first charge over the assets of the company. If this sentence, you must find out under which law they are filing a claim, and in that law whether this sentence is there or not. So don't treat any statutory dues as secured creditor unless you find a similar sentence in the law. So it is your duty to find out. That is one thing you have to do. Now, coming to the second part of it. I think a lot of GST experts are here. What is the section in which the GST dues are also treated as a first charge? Section 82. Just read that section 82 and compare it with the language of section 48 of Gujarat VAT Act. Section 82 of GST, what it says, interest, tax or penalty shall be the first charge over the assets of the company. And then they have used another phrase which is missing in Gujarat VAT Act, and it says in commas, subject to the provisions of IBC. Now, this sentence, subject to the provisions of Insolvency and Bankruptcy Code 2016, was missing in Gujarat VAT Act. And logically so, because Gujarat VAT Act is of 1948, they could never have anticipated that there is going to be, you can say, act which is coming in 2016. So naturally, that sentence is missing. GST Act came later than the IBC. So therefore, it is subject to IBC. So now there can be an interpretation that, look, you are not secured creditor because IBC does not say so. In any case, assuming section 330, 331 says that they are secured creditors. So assuming if I apply the same logic of the Supreme Court, they may be treated as secured creditor. Let's take the case at the highest. So even GST department is treated as a secured creditor. But now the Supreme Court in that case, Rainbow has said that they must be paid along with the bankers because they are the secured creditors. Rather, they should be paid before the bankers. Now here, I can dispute that. The reason is simple. that here the interpretation of the Supreme Court is little flawed, but of course it's a Supreme Court, we can't say anything. Ultimately, it has to be decided in some other case or maybe a larger bench later on, because the review application has also been dismissed in this case. So what the intention is? If you read section 53(1)(b), what does it say? 53(1)(b) says that the amount after the payment of CRP cost and liquidation cost has to be distributed in proportionate to the secured creditors and workmen. 24 months dues, right? This is the clause. So if government dues are treated as secured creditors, so they will fall under 53(1)(b). So now they will be paid along with the workmen and the secured creditors. So 53(1)(b), that is the platform for them. But according to me, this interpretation is not correct for a very simple reason. Okay, so the if you look at the 53(1)(e), which is the fifth level, now it says government dues. So government dues as per IBC are to be paid at a fifth level and not at the second level, 53(1)(b). So if the provisions of GST are subject to the provision of IBC, and if you read the opening sentence of section 53, it says notwithstanding anything contained in any other law for the time being in force. So therefore 53 read with 238 is superior to section 82 of GST. So under GST, even if they are treated as secured creditor, no quarrel, but still they will be paid under 53(1)(e) and not under 53(1)(a). That is first logic. Now, how we are coming to that interpretation and logic? Let us look at this. I just mentioned about the preamble, and I said preamble is a great source of understanding the jurisprudence. Let's go back to the preamble once again. There is one preamble which is mentioned, which says this IBC has been created for balancing the interest of stakeholders by altering the by altering the payment of the government dues, by alteration in the priority of the payment of the government dues. Now, why this sentence has come in IBC? Let's go back to Companies Act. Companies Act also had similar provisions. Companies were coming into insolvency and winding up or liquidation. It's not today. It is coming from 1913 Act of Indian Companies Act, isn't it? आज का नया subject थोड़ी है. So if any money is with the liquidator, how that money is to be distributed was already mentioned in the Companies Act. This is nothing new in IBC. So, but there was slight difference in Companies Act. Companies Act said, first the liquidation expenses are to be paid. Then they evolved a concept of super priority. Super priority was given to secured creditor vis-a-vis the workers. And then on the third level came the preferential creditors. And preferential creditors were treated as the government dues. Government dues were treated as preferential creditors. But the concept of preferential creditor is missing. So they came at that level. But when IBC came, the lawmaker said, we are balancing the interest of stakeholders by altering the priority of payment of the government dues. So they brought government dues lower than the financial creditors, secured or unsecured. So they brought them at level number 5. This is the objective and mentioned in the preamble. So read with this preamble, naturally the government dues have to come below whether they are secured or unsecured. This is the logical interpretation. So therefore, my dear friends, the rainbow jurisprudence does not apply because that was applicable only in case of Gujarat VAT. But whether they are to be paid in priority or not, according to me, they are not to be paid at priority. So what I have suggested to the government, and I think I wrote an article also, a detailed article, and I have suggested that, look, in clause number 53(1)(b), you have written the word secured creditor. Just change it to secured financial creditor. The moment you add the word financial, the government will be out because government is an operational creditor. Today the confusion is coming because the word secured creditor is used there. So secured creditor can include both secured financial and secured operational. But the moment you clarify it as secured financial creditor, the matter is over. So there is no need of interpretation. Otherwise, even otherwise, the interpretation is 53(1)(e), they come whether secured or unsecured. Or secondly, they can also do another thing. In 53(1)(e), they can write down government dues, comma, whether secured or unsecured. Well, you clarify that, if that is the intention. So rainbow can be, you see, get over with that. So don't bother about it, friends. There is nothing wrong in rainbow. There is nothing which is impacting. Yes, the VAT department, the sales tax department have become proactive nowadays and filing claims after claims and applications after applications basis rainbow. Unfortunately, in one of our cases also, they said they relied upon rainbow. I said, my learned friend probably has not read rainbow. Rainbow is a different judgment and I can distinguish. And then the other guy could not answer it. He said, my lord, I need time to argue on this. I said, fine, you take time. So at the end of the day, let that come in some arguments. We will deal with that. So I hope I'm clear on rainbow. Any questions on rainbow? I think we can cover it. Okay. Yes, sir. Go ahead.
Only one.
Thank you, sir.
Can I come in?
Yes, sir. Go
Mr.
ahead.
Sir, I had one clarification actually.
I think after Mr. Ramesh speaks, so you can ask your question.
Okay, sure, sir.
Yes.
Sure.
Thank you, sir. Just a clarification, not even really a question.
Right.
When there is a non-obstant clause, like
Okay.
Section 238 in IBC and even in Companies Act, you find many such examples of non-obstant clauses in various sections. Can that be taken as a blanket power for the courts to exercise inherent powers?
See, inherent powers are something different, sir. Let's not mix it up with
I'm just
non-obstant.
thinking, because I'm trying to link these two, because there is some ambiguity as far as non-obstant clauses are concerned. And given that we don't, as professionals, tend to agree with a few judgments, we often pass comments about whether this judgment is good or bad. Could it be possible that both can be linked and in a way to find redressal for an aggrieved person who has no other remedy?
Okay. See, let us understand a situation. What is non-obstant clause? Let us also try to understand. Non-obstant clause does not always mean notwithstanding. I will give you 4 or 5 phrases and I'll request my friends to note it down and try to find out the difference between all these sentences. Now, this is very interesting exercise for all of you. The first sentence is notwithstanding anything contained in any other law in force. Second, subject to the provisions of section so and so. So subject to, that is the second phrase. Third phrase, which is used as save as otherwise provided. The fourth phrase is without prejudice to the provisions of so and so. And the last non-obstant clause, generally when we see, is except as otherwise provided. So look at this style of writing. Notwithstanding, without prejudice, save as otherwise provided, except as otherwise provided, without prejudice, and so and so. So every sentence has got different meaning altogether. So I will request all of you to please look at these 5 sentences. And the best way is to go to Companies Act. In Companies Act, you will find all these phrases. So try to read those provisions and try to find out what is the difference between all of this. That is one part. Now coming to his question. Notwithstanding is to be seen and interpreted in that context only. It has nothing to do with the inherent powers, sir. Inherent powers are completely independent of non-obstant clauses. And you mentioned about section 238, sir. 238 is not a non-obstant clause. 238 simply says the act will override, and you have to read it with a huge pinch of salt. It says the provisions of IBC shall supersede all other laws provided there is an inconsistency. So IBC in general does not override any other law. Please understand this. Let's take it out of our mind that IBC is something which will override all other laws. No. Only if there is inconsistency between two laws, then IBC will prevail over the other law. And their best judgment to read on this is Shilpi Cables versus Macquarie Bank versus Shilpi Cable. I think some of you must have read it. Macquarie Bank Limited versus Shilpi Cables. Supreme Court judgment. Here the Supreme Court considered the clash between IBC 230 clash between IBC and Advocates Act. And Supreme Court ultimately came to a conclusion that Advocates Act talks about something else. IBC talks about something else. There is no clash. There is no inconsistency. So therefore, neither of the act overrides another. So IBC cannot override Advocates Act because both are operating in a different sphere altogether. So if there is inconsistency between two laws, only in that case, IBC will prevail over the other laws. So please read it with a pinch of salt, 238. That is very, very important. Now here we were talking about section 53. In section 53, there is a non-obstant clause, notwithstanding anything contained in any other law. So if other law says government dues are considered secured creditor, they will be paid in priority. Sorry, I will not pay in priority because my IBC says they will be paid under 53(1)(e). IBC overrides, read with 238. Because now there is inconsistency. One act is saying, no, you pay in priority. Other act says, no, I will pay at fifth level. So therefore, that is my conclusion. Logical conclusion that government dues fall under 53(1)(e) and not under 53(1)(b). That is what my logic is. But for the sake of clarification, I think MCA will do better if they just clarify that. Yes, ma'am, please go ahead. Yes, Prajakta.
Sir, I just wanted to reconfirm. Yeah. Sir, actually, I'm a liquidator and I have a VAT claim and I have sold the assets and I have sell proceeds and I have to distribute now. So I just wanted to clarify with you that you said that that review petition has already got dismissed. So is that true? That
Yes.
Rainbow review petition is already dismissed now?
Yes, yes, it is already gone.
Okay, because Maharashtra VAT also has a similar clause which creates first charge on the assets. So then as a liquidator, what is my duty? I mean, when I'm distributing, I have to take into account to Rainbow.
See, you have to, in Maharashtra VAT, assuming that is there, I think the similar section is there. I understand, I think section 54 or something is there. So you treat them as secured creditors. If that same clause is there, you treat them as secured, but they are secured operational creditor, right?
Okay.
Then you pay them in accordance with section 53(1)(e) at the fifth level. Don't pay them at 53(1)(a) level. Because I'll tell you, Rainbow is not a judgment for liquidation. Please understand.
Yes,
Rainbow is not a judgment on payment to payment in liquidation. It is a judgment where they're quashing the liquidation order has been quashed. That is a separate issue altogether. So it is not, you see, where the approved resolution plan has been quashed.
Resolution plan was.
So therefore, it is not a judgment in liquidation. You can always present to the authorities, adjudicating authority, that sir, this is not a judgment in liquidation. So therefore, you can't take that as a full authoritative judgment on this aspect. And in any case, the logics which I have given you, 53(1)(e), they will fall under as secured operational creditors. No doubt about it. So don't pay.
So should I seek directions from NCLT only by making an application?
If you seek directions, they will not give you. They say, sorry, we are not going to give you any directions. You apply your own mind. I'm telling you. So what you can do is just to safeguard your this thing, you take a legal opinion from a lawyer and save your skin. Fire the gun from the shoulder of a lawyer. Okay, a law firm ka, legal firm ka le lo, so that you get a complete support that why you're distinguishing from Rainbow. So once you have it in your file, then you distribute it. And if somebody questions it, you go to the NCLT later on. But today, if you go to NCLT will not decide. They say you apply your own mind. Why should we come to? They're
Sir,
not
I have already
giving
taken
advices.
legal opinion.
Sorry?
Sir, I have already taken legal opinion, and legal opinion unfortunately is saying that I have to follow rainbow. So that's why I'm in dilemma, because I'm also with you. I fully agree with you. That's not the intention of the law.
Correct. I've given you logic.
So,
I've given you logic. So
yeah.
I don't know what logic the other lawyer has, because you see, most of the people are believing in rainbow and just going with the flow. That's all. So it's a very colorful judgment. Okay. But that does not apply in
Sir,
your
as a
case at all.
liquidator, do I have a duty to inform the VAT department that I have sold assets and I'm holding the sale proceeds?
Well, you are not, but nowadays, since they are part of the SEC, because now SEC has been broad-based, isn't it? So they are part of the SEC. So in SEC, they will come to know of it that money, this has been sold and now this
They
is
don't attend. They have not attended a single SEC meeting.
does not matter. So if you are giving them a notice and they're not attending it, then they can't have a grievance before the court tomorrow. So you discuss the distribution plan before the SEC, and then you distribute the money according to whatever you think it is fit and based on the legal opinion. But unfortunately, you got a reverse legal opinion, तो आपके लिए तो बहुत दिक्कत है. अब आपको किसी और से लेना पड़ेगा. So therefore,
thank you, sir.
Yeah. So okay. Anyhow, that's a great discussion. Okay. I think everyone is facing that problem. So friends, I think I've already taken a lot of time. We are almost at the end of the time now. So any questions are there, friends? So any more questions or any experiences which you want to share of your with the adjudicating authority? So I'm only going to say 2-3 things. Insofar as adjudicating authority is concerned, friends, be their friend. You are not opposing the adjudicating authority. Support them. You are an officer of the court. So go with the flow and give them complete facts with complete honesty. And definitely they will understand your problems now. So even the benches are understanding how you see RPs are facing the problem. But at times, of course, they are also pressed with the time. So therefore they are not looking into it. But definitely you can impress upon them. So have a good knowledge of the facts, good knowledge of law, present your case in a very, very polite manner, but within a firm manner. I always use the word firm and polite. Address them properly, very politely. And whenever you are appearing, wear a dress where you look like a professional, right? Don't wear a t-shirt, don't wear a hoodie, don't wear a multicolored or something like that. Wear sober colors, right? Typically black and white, grays or something like that with a tie, I think that will do. And ladies definitely understand what is the sober color and what kind of dress they have to wear. I don't have to explain that. So all these things really do matter. They make a difference. And whenever you're appearing, say, what I call it as, say, physically, then you have to be very submissive, right? Your shoulders must be looking as stooping shoulders, where you are asking for some prayers. So be very submissive. Don't be arrogant about it that you know better than the bench. No, it can't be. So whatever they say, you have to say, my lords. And if the order is passed in your favor, not in your favor, you will say, obliged, my lords. And if the order is passed in your favor, you will say, deeply obliged, my lords. Okay. So you will always be obliged, whether normal obliged or deeply obliged. So you'll have to be grateful to the bench only. So thank you, my dear friends. I'm also deeply obliged to you for hearing me patiently for almost 3 to 4 hours.
Sir, we all are deeply obliged to you. We all are deeply obliged to you for such a nice presentation.
I think
as a teacher.
No, I belong to your fraternity, sir. All my friends, I treat everyone as equal. I'm just sharing my knowledge, which is with me. That's all. And I think I've also gained a lot with your experiences and your questions. Definitely, it is also helpful to me. So, friends, last opportunity. Any more questions? Any comments? Any feedback? Otherwise, I'll hand it over to the ICSI.
We are grateful to you.
Thank you so much, sir.
Chalo, grateful. Thank you so much. I think over to Trishla for your closing comments.
Sir, on the behalf of ICSI and IBBI and all the dear participants, I would like to thank you for this session. Thank you so much for keeping this event in your schedule and for this wonderful presentation. I believe you did complete justice to the subject. Thanks a lot, sir.
Makhija sir,
I
can you
don't know.
please share the presentation, sir?
Yeah, definitely I'll share it, sir. I'll definitely share. I wanted to do justice and I would have done it, Trishla, because I'm in US right now and it is 3:33 a.m. now. So I have to go and
Thank you very much.
Thank
Mr.
you, sir.
Ashish
Thank
ji,
you.
deeply
Thanks a lot, sir.
wonderful
All right,
presentation.
sir.
Thank you, sir.
Thank you.
Thank you so
Wonderful
much.
Thank you so much. Thank you.
Thank you, friends. Have a great day.
Sir,
Have a great
we have come to a news that there is very cold wave in US. So what about where you are staying?
Yes, sir, you are absolutely right. It is -15 temperature out here.
Yeah, we have come to know.
Anyway, ठीक है, यहाँ पे सब everything is centrally heated, cars and everything,
Yeah,
so
yeah,
you feel that impact, but you are
Okay,
staying.
sir.
Okay, sir. Take care, sir.
So
Thank
when
you so
should we
much.
welcome you, sir, in India?
Next week, sir, I'll be there.
Oh, very good, sir. We will meet physically. Okay, sir.
Great, sir.
Thank you.
Thank you.
Thank you.
Bye.
Thank you so much.
Thank you.
I would also thanks to Rajesh Kumar Gupta sir for being present here in the session and delivering his remarks in the morning. Thank you so much, sir, for being here. And I would thank all the participants. We will meet tomorrow for our fourth session.